Yes. Cannot be. A report is there, SIT report and scan copies. You wait for your turn. Because there is an order for the report of SIT report and the scan copies of the case. Yes.
We have item number 65. Now we have five written arguments today. So we are saying that we will be allowed to
65. Okay. Yes. Relating to senior bench. Only, not by that bench. Okay. What is the urgency? Bails, if is pertaining to these bench, all allowed. Okay. Yes, quiz. Yes, madam. 40 and yes, now any interim? When? 19th. See, interim to continue. Huh? You want an adjournment? 20th of interim is there? Yes. In 50? You are for? This is 2009 meters. Sorry. Yes. Interim is there? When?
20th September.
20th. Yes. 19th. No interim.
Okay,
22nd.
Yes.
Interim to 36. Okay. Interim to continue. Why? Who filed against the okay, we'll call it. Give us slip. Series there? Okay, call the, give the slip. We cannot retain the CD. That is the ground, so we'll call it. Give us slip.
Be item number 1.
recovered to the satisfaction of two of the petitioners here. How can you file a bail application when it is pending here?
After handling the case,
No. How many petitioners are here? He has been released on bail. Then why are you saying we are allowing this? To tell us what is the to the satisfaction of Mosalpur what? Civil Judge Senior Division.
Yes.
Huh?
Yes.
Additional judicial magistrate must have property has held.
Item 2,
At least come prepared with that. In the event if you are granted bail to the satisfaction of whom? You are young counsel, at least that should you must know. Yes, to the satisfaction of, yes. 25,000.
3,
To the satisfaction of 25,000.
item 4,
Yes, 50 is 16, he is 19. But affection is there is an age for affection. That is the problem. Parliament has they fixed some age. That affection can be after that age. How many days? 21/8. Where is the guard? Where is the guard? Forget about. I am asking a question. Where is the guard now? Huh? With you or with her family? No, might be. Whether guard is recovered. Where is the forwarding report?
So after what the Dallas report was, what kind of case
This should be covered from the position of the petitioner.
When can you have the case diary? At the earliest? 13. 13 at the earliest. Difficult. She's 16 years. We do not know whether there is affection or ill will to send her to Rajasthan. Difficult. So we'll have her including her statement. Steady.
item number 5,
Transited matter was arrested on basis of LBW issue to 93 days. They are also local bottom of the same locality other than.
But only thing is that do we need to, is it not necessary to see the scan copies?
No, it is a MBW, it is a arrested.
Oh, NBWA. Where is the order?
Order was to be found on page
3012.
page 18, 93 days. Page 18. Accused so is put under by the arrest by subsidiary of the state of MBW. That is what before law. And in the eight lawsuit, the was arrested at the time of filing of the FIR.
Subsequent, who was arrested during that period?
During the period,
Released on bail.
release on bail.
Anything? Have you annexed that?
Page 50.
Page
Page 50, the original one. So can you see the third column was it in custody.
Heard Mr. Munir, learned counsel for the petitioner. This is an application under section 439 of the Code of Criminal Procedure for grant of regular bail to the petitioner. Full stop. Full stop. An affair was lodged by the informant on 11 to 2016. Alleging that some unknown miscreants kidnapped the nephew of the informant. Subsequently, during the investigation, the petitioner was arrested and was released on bail. After completion of the investigation, the present petitioner was searched and was sent for trial. Full stop. You appeared sent for trial along with other 3 accused. Is not it? 364A. No? Charge was also filed under 364A, and the petitioner, along with 3 other accused, were sent for trial. Full stop. When have you released on bail? Earlier during investigation?
But in the clearly says he was in custody.
When charge sheet was filed in custody, but we'll have to record that subsequently he was released on bail. Thereafter, NBW.
Because those were second
Steve, you see in custody, Sri Horan, Sri Uttam, Sri Riten, Sri Binod. So on the date of filing of charge sheet, you were under custody.
No, the second column, can see these 2 persons were arrested and they were during custody of the charges was filed, so their name was given.
Now understand,
And they were released, so they were subsequently given in the second column. That means they were at that investigation period, they were in custody.
now if you come to page 15,
Not it.
if you see in custody,
Not it.
there is a tick mark.
Not it. Those persons were released, and these 2 persons was Sutra and Noran Prautia was.
Name of the address of a person not sent for trial,
Not it.
whether arrested. This is column 2.
Or not. This is the person who were in custody and at the same time charges were filed. And the third one is so these 2 columns were there. They were at that point of time, they were in custody and the charges
Now,
were
kindly, I'm not getting your point. If you come to page 15,
not it.
this is a charge sheet, part of charge sheet.
Not it.
Now we have 1, 2, 3, 4 columns.
Not it.
Column number 3 is having 2 sub columns. Okay. It says name and addresses of the accused person sent up for trial.
Not it.
There is a tick mark.
Not it.
Okay. Then there are 2 columns. One is on custody, other on bail, etc. Now, in custody is tick mark.
Not it.
There your name is there.
Not it.
Sri Horan Kormakar. Forget about others.
Not it.
Okay.
No.
So on the date of charge sheet, you are in custody.
No.
According to this.
No, on bail also they next column also they what the both column.
On bail, not tick mark.
No.
On bail, not tick mark.
No. At the
Tick
time of-
mark is sent up for trial in custody.
No, that I understand what you because NTW will not be issued of the-
Understand, but it is you, the petitioner, is coming saying that I was released on bail. So your release of bail should be subsequent to filing of the charge sheet.
No,
Where is that?
that I am-
In absence of that, we'll have to call for the scan copy. No, no, there is no question of kindness. We are guided by law. We are not monarch to have kindness to give somebody to something and not give something to somebody. Yes.
The person were arrested at the same time charges has been filed, also they were given in this column. And this person in custody and on bail.
No, no, your understanding, please show us why there is no tick mark in on bail. Why there is no tick mark? And so far relating to name and address of the accused sent up for trial, there is a tick mark. And there is two column. One is custody, one is on bail. And a tick mark is in on custody.
You will get out of it, so NBW has been, if you only the date, I don't know. Just
Call for the scan copies.
but then, Monday, if I can produce the order.
How you produce it? If you produce the order, we'll allow you to go on bail.
Monday,
We must record something, na? Can we record that due to my kind heart and kindness, I am allowing this bail?
sir, okay, I'm sorry.
There is no rule of kindness. There is rule of law.
Monday.
Yes, Monday, on the prayer of the learned council, this is on Monday.
Item 6. 11.
Yes, FIR against you is page 18. And FIR file by your brother is page 22. Where is the FIR? What is the allegation at page 18? Your brother lost the FIR on 4/7. And against you, it is lost on? Okay, let him go. To the satisfaction of CGM, somebody said additional CGM Masalpur. Yes, madam. So earlier also CGM Masalpur.
Item 8.
Huh?
Additional affidavit of second position.
Okay. Where is the FIR? Where is the FIR, Munir? Let him go up to the satisfaction of CGM.
Much of the.
So, come. Yes, Argo. Why should we?
There are certain.
You got married. Now you.
Actually, one thing of some persons of the accused person has taken us that I should withdraw the case, and so I need to file.
You are sitting behind the back. Huh? The moment bail is granted, you stand up. Where is your, have you filed wakalatnama?
Was it today, morning I have filed.
This is not a case for grant of bail.
So at least in civil,
At 2. To come prepared at 2.
Item 9.
The learned counsel for petitioners raised for withdrawal of the present petition and to file a fresh prayer is allowed accordingly. Prayer is allowed accordingly. The present grade application stands dismissed on withdrawal, which a liberty has paid for.
10.
Case diary. When, madam? 14th.
11.
Case diary.
12.
Yes, Mr. Garudia. Case diary. When? Huh? 13 same.
14.
You are directly on 86 for 2020. Trial is going on, and the trial court is not allowing the place on the ground that after the
That is the proper proposal.
I am not the main issue. The entire one.
What is your name? Prabal. Who is the affair? Any statement of the victim? But you must have, because trial has come in. That is very important. Had you annexed it, you could have considered, you have not annexed that. Is an application of so. Registry to call for the scanned copies of LCR and status report. Scanned copies of LCR and status report, including the statement of the victim record, also the scanned copies of the case diary of so and so case. Huh? Whatsoever. That's why I'm calling the CD. Huh? You got it? Because
More than 4 months.
20. Huh? Register to 4 or 4 people. Item number?
15.
Yes. CD. $50.
For bail hearing BA, item number 20.
Is there? Give a copy today or Monday? Tuesday. Monday. We'll consider it Monday. The scanned copies called for by this court is received. The learned additional public prosecutor wants to go through the same go through the same. Accordingly, matters stands adjourned and be listed on Monday. Give the date. Tuesday. Wait. You want to be inside for 2 more days? Okay.
Item 21. 21 also schedule the slot so that we have not received.
Where is the affair?
All material revenue from the finding of yes,
Page 8 is the affair. How many days? Where is the forwarding report? Be there for some days so that you don't give biscuits to others. I'll search it at the earliest and let him eat biscuit inside the jail. Have the PIP. When? 15th. No, CD is not received again. Bail.
15 months. Item 22.
Yes, Mr. Mahajan.
Two cases
Hmm.
and two checks related into one form. First one was second granted, but it was second. 1 month.
Now we have slowly changing the attitude.
Fine.
So far relating to snatching.
I did not buy it at the first instance. It was melted by some other jeweler. May I did it, my lord?
Yes, where is the affair?
Hello, after here it is, my lord, case 9.
Case
It
9.
has nothing to do with the rank.
How many days?
30 days. And consider granted the other one, my lord. Second degree. And there is the line, my lord, it could be FR, and I did not buy it, solid from my lord. From the statement of accused person, it has been known that he, along with co-accused, is the two gold chains from Udavari area. And later they have planted the stolen gold chain at Brookfielding Jewelers that belongs to somebody else, owned by Asuk Bhaspate. And later,
You are the jeweler.
second jeweler.
Don't buy.
I'm not buying. That time also I got
Yes, record it, his name.
mine.
If we get that he buys and mails again,
Mine.
we'll ensure that charge sheet is filed within
Mine.
30 days.
Value of it.
23.
It is same.
10 copy of the case study was 12.
Yes, is it clear? Not received.
19 cases are in custody. This is the day of it. 40 cases.
326, 307, 34. Okay. The scan copy office note dated 1/9/2023 reflects that scanned copy of the case record called by this court under its order dated 25/8/2023 has not yet been received. Full stop. Registry to issue reminder forthwith, in as much as the matter involves a life and liberty of a person. List this matter on viewer date 20.
Supplementary list item 68.
That's what I want to material.
Yes. Burua, anything? No, not scan copy. We call something different, no? Okay. What is the name of the present accused? Manjur Ali. I think this we have seen already, but this we have already seen. But only thing was that he was not even been not produced before the court during the trial on the ground for the reason that he was sick, he could not be produced. Then he was hospitalized in Dhubri Medical College, then was referred to Guwahati, then he was released, again was in jail, again to the hospital, again back to the jail. So therefore, on medical ground, he wants that he needs some better treatment. He may be allowed to have a better treatment on his own cost with a company from his family. So accordingly, we passed an order on 1/9/2023. MS Endas was supposed to give a report, and it's reached that a copy of the order we furnished to MS Endas, Learned Additional Publisher for State of Assam, for onward transmission to the Superintendent of District Jail to be. I think this was on first. Thereafter, there is holidays. But what happened is, she left for her residence on the date itself after this order was passed. So I think this copy was not been able to serve upon her on that day. I verified it. I think so. So can you have it after Monday? Telephonic also, if you go through it, you will have it, will take it tomorrow. You get a copy downloaded from the website, or we'll give a copy. Huh? Give a copy to Borua, last order. And you have the instruction, we'll take up it tomorrow. Tomorrow at 2. Okay. Okay, release this method tomorrow. In the meantime, Mr. Borua, learned additional public prosecutor, shall obtain the instruction in terms of order dated 1/9/2023. Huh? Only his matter element. Others will see there are specific allegations against him, but we are concerned about his health. Because admittedly, if you go through the record, it was specifically, it was not produced, court recorded that due to his ailment, he could not be produced. And thereafter, it is on record that he was treated in medical college, then he was in Dhubri Medical College, then again back to hospital, back to jail. Now he said that he's still not keeping well and want to have a better treatment. And for that, he wants a limited period of either bail or his liberty to have treated in a hospital of his own choice with accompanying or 6 weeks or 7 weeks. That we can consider very well because it's a question of his health. Okay, and he's not yet convicted. Trial is going on tomorrow. Give a copy to Mr. Borua, last order from downloaded from.
Item 24.
This is AB. No interim. Interim is there. We'll continue the interim. 18th interim to continue. Huh? Signal issue with you. Interim.
25.
Cities there, Mr. Borua? Okay, same order. Interim to continue. 25.
27.
26
Okay. So, seated, you are on interim. Okay. So what to do today? Okay. The learned counsel for the petitioner submits that petitioner or petitioners, petitioner submits that in the meantime, the investigating authority has filed search sheet in connection and the case has been registered as PRC case number 74 of 2023, which is pending before CGM D4, and the petitioner has also received summon in this regard, and the next date is fixed on 16th of 16/9/2023. In view of this, the present bail application, anticipatory bail application still closed, and the interim. Have you recorded this statement? An interim order was earlier shall continue till the consideration of a bail application, regular bail application by the learned CGM on appearance by the petitioner.
28.
CD call for not to receive, interim to continue. When Mr. Borua? 26/9. 26/9.
29.
Borua? Interim to continue. Date
26.
26.
30.
Similar manner, I am referring to. No, that is submitted.
First it's submitted. Has he sent for trial? This person is also sent for trial. Okay. Being search sheet number
Article number 309/2023, dated 24/8/2023.
what are the sections?
FIR was under 447, 386 and 34.
Triable by
Myself.
mistake. Same order. Agar dito dilo. Till appearance. Summon naipo. Till appearance on summon. About it, in the earlier case, there was someone was already issued. In this case, someone is not issued. So we have orders like that.
31.
Is the receipt? Yes. Where is the FIR?
FIR case number 11.
Roful Amin.
Yes, madam.
Hosumi. This is Salam.
You are the secretary.
You are the
Secretary of, Infra Asset Limited.
okay. Lusunbari SS Limited. Dumkur SS Limited.
The secretary of Lusanabari Asset Limited under the Infra Asset Limited take the Lusanabari Asset Limited.
Yes, is it this records are recovered from him?
No, my lord,
This is not a case for anticipatory bail.
my lord, there are my lord implicating measures against this partial lawsuit. And what is 234 quintal.
235 people. I've seen this.
And that is for the public distribution.
Public distribution.
And on the day of event also, while this mother, it was scope of taking mother, on the day also here, mother, he did not appear.
He did not appear plus records.
Higher case was illustrated.
So I think again get arrested. If you are habitual offender, that gives you know right, because if you were earlier also arrested. So you read 438. Read 438, you are not entitled for privilege.
Yes, my lord, because I have connected by higher FIR also. I have
The
connected
executive officer also
earlier.
can some objection, my lord. I'm taking my lord, actually.
Then, when I investigate, with the order of the state. At that time, madam, in earlier case, madam, you are satisfied, but in this case, after release of madam, on the case, madam, this case has been released.
Where is the earlier FIR?
FIR, madam,
Is earlier FIR relates to the same incident?
yes, madam, same incident.
Where is the earlier FIR? Tell us.
FIR case, madam, 2018.
this notice, this detailed size notice, that is what we need to work with.
But these are different. These are fair price stop owners, beneficiaries.
Yes, if I say from October is November to be. Now he is holding the postal notice.
Wherever he is there. Yes, Argo. Yes, what happened?
He actually needs to set it up with one of his numbers.
Ah,
And by the Kumbra, was stayed with one of his numbers.
yes.
And by the time they will the mother, seal the dated 29/11.
Which page?
Page 25. On that date, which the mother Godan was seeing.
Okay, go down or seal. See.
But somebody regarding somebody case was registered. This was registered and he was arrested and in jail. After release from the jail, this case has been registered. Whereas with the Godan was seen, same deadline. All the documents, clearly documented everything.
Now, this allegation is related to the misappropriation of Jhumkura SS Limited.
Yes, madam.
Where is the present FIR?
Present FIR case, 11.
Mr. Bura, this is only reopening and measurement.
Yes, madam.
Allegation is that he has misappropriated. So actual misappropriation could not be determined. Therefore, Jhumkura that Godown was sealed. And this FIR is the verification of the actual amount of misappropriation. So it's a continuation of the earlier. Where is your earlier arrest memo?
Yes, forwarding with 69. Yes,
In the hardware case, he was granted of 25/1/2023.
Okay.
And this FIR was closed on March 2023.
No, understand. You just correct me. If we go by different allegations were given by three classes of people: the beneficiaries, actual who did not get the rice, EMYG and something like that; the agents, that is those fair price shop owners, that we are not getting, he is misappropriated. Then accordingly, it was not properly, could not be properly verified, so the godown was sealed. And on the basis of that affair, he was arrested. Now subsequently, he was released and godown was opened in presence of circle officer. Calculations were made. Then it was verified that 353 quintals were misappropriated, A minus B. So, a same godown. It was sealed in pursuance of the earlier affair. Now it is open. After opening, the quantity is determined. So subsequent can be treated as a part of the earlier affair. So he cannot be arrested twice.
That is two notices.
If-
Case 20 notice.
Place 20.
Case 20, this is the FIR, present FIR notice.
Huh.
By this act, the Rahul Vipul Amin, the then secretary of Rosenberg Congress Committee, who is also the operating of Mr. Ankula. This is the present Congress Committee Limited.
Where page 20?
Close.
Page 20, which page? Violation.
Bail application.
Page 20, violation. That is, you are reading.
Roughly violated the clause 1426 of the Assam Public Utility Article Order 12. And with support the previous right, and with the my lord, clause 510 11-13 of the previous control.
No, that we understand. That could be verified only after de-sealing of the godown. There were allegations that there is misappropriation. So he was on the basis of that FIR lost, he was arrested. He was in custody. Hereafter, to verify the godown was de-sealed, and it was found that these are the offenses done. So this can be a search sheet, not an FIR, or can be a part of the investigating procedure.
All the documents.
If operator losses in after getting the interest, before the time of sitting or calculating he was asked to in the secretary.
Because he knew so therefore he was arrested. He was not cooperating, so he was arrested. Isn't it? Where is the earlier arrest? Yes.
69.
Considering the other thing that the case diary produced is perused. It is seen that where is the earlier affair?
Case 28.
Page 28. Case diary produced also perused the documents annexed with the bail petition. From the material available on record, it is seen that an affair was lodged by the Inspector of Food and Civil Supplies and Consumer Affairs, Morigaon, alleging that the present petitioner, misappropriated materials meant for public distribution system, and he being a secretary of Dhumkura SS Limited. Such affair was lodged on the basis of complaint made by the beneficiaries of such scheme as well as some agents. On the basis of the aforesaid FIR, a case being, what is the case? Case being Lahori Ghat PS case number 116/23 under section 409, section 420 and 468/471 IPC was registered and the petitioner was arrested. In the meantime, the godown where the material meant for public distribution system belonging to Dhumkura SS Limited was sealed. The petitioner was released on bail by whom? This court, huh? By this court under its order dated 25/2023, passed in bail application 290 of 2023. Subsequently, the godown was de-sealed in presence of the local circle officer, and it was found that total amount of 235.34 quintals of rice were missing from the godown. Accordingly, yet another FIR was lodged. FIR was lodged against the present petitioner, which was registered as Lahori Ghat PS case number 116/23 under section 409/420/468/471 IPC. Full stop. This court, considering the matter in entirety, granted interim protection to the petitioner by an order dated 11/4/2023, full stop, 2023. The 2023, with a condition that petitioner shall appear before the investigating officer within 7 days from the date of passing of such interim order. Accordingly, the petitioner appeared before the investigating officer and record reveals that he has cooperated. Full stop. Considering the aforesaid and also the fact that the subsequent FIR also arises out of the same allegation, this court is of the view that custodial interrogation of the petitioner shall not be necessary. Accordingly, the present bail application stands allowed with the earlier the present bail interim order is made absolute in terms of the earlier orders, with a further condition that the petitioner shall not leave the petitioner shall not leave the jurisdiction of the local police station without the permission of the investigating officer, as well as he will appear before the investigating officer as and when called for. With the aforesaid observation, the present bail application stands disposed of. The case diary is returned.
33.
Yes, who is the case diary received, Mr. Abdullah? Who is the FIR? You are Ariful Ali, accused number 1. Who is the earlier FIR? Where is no, her statement was recorded. The victim's statement was recorded before that. Where is that?
In respect of case number 71.
We want that.
We have to call for the present case.
Okay. See, Mr. Counsel, there is a specific allegation that there was a threatening on behalf of you.
I was on.
Maybe we'll consider it. You are on interim. We'll consider that. But we want to see the earlier case there. How and in what manner this was ended to such a tragic. Why will she suicide if she was recovered? What was her statement in the earlier? Yes. Ultimately, it's an anticipatory, not a regular. Okay. Peruse the material available on record, including the case diary produced. However, this court is of the opinion that for proper determination of the present case, the case diary of Soygaon PS case number 71/23 under section 365 shall also be necessary, inasmuch as in that case the statement of the victim girl who committed suicide subsequently was recorded. list accordingly. 25/9 interim order pass earlier fell copy.
34,
Yes.
Here also I have interim order.
Mm.
Here now with the he is like
Muzammil Hussain. Still, detention is not necessary.
PM is not there.
Huh?
PM is not there.
She had the air bubble inside her nerve. He committed mistake calling a pharmacist to infuse this. And right.
From the city to see that I just like to point out that
Yes.
pharmacy is the value by the petitioner.
Yes.
It is found to be illegal.
That may be a cause of not having proper hospitals. Where will these villagers go? Anyway, if you want to produce the postmortem report, he is in interim. We'll protect him. Okay. Though the case diary is received, the learned additional public prosecutor submits that the postmortem received is yet to be received. Accordingly, he submits that matter may be adjourned. Where is allowed, matter stands adjourned. The case be listed on 25th of September. But think that you have a coordination of October 28th. Before that, it will be very difficult. Hundreds of cases will be there.
And in September.
Okay, 25th of September 2023. Interim order pass out. Let us have this at have us this at this.
35,
Yeah, people.
Yes,
I am doing.
yes. Series. What is the allegation? The petitioner is Marzina Khatun.
Yes, our husband died.
Okay.
Accident. And later on his mother, I can have alleging that we have deal. But in the FI itself, it says that on 25/5/2023, at about 5 p.m. my son went to his in-laws house and when he
Just give me a minute. Just give me a minute. We are not. Who is Rubzan is Her mother of the deceased, you are not giving anything to her, that's why she lost the affair. Have you appeared?
Yes, Lordship.
The statement recorded, considering the nature of allegation. You are also there. Yes, Mr. Abdullah has vehemently assisted the learned public prosecutor and objected the case. Otherwise, you will entitle. You approach in different. You will entitle for that money.
Let my comment to the argument.
No, he'll not. Certain things we should not go into. Abdullah, Harald Abdullah, assisting professor for the informant. Considering the material so far collected and the nature of allegation made in the affair, and also considering the fact that the petitioners had cooperated with the investigating authority. This court is of the view that no custodial detention is required. Accordingly, so absolute.
36.
Interim. Series there.
CD is not there.
Okay. Interim to continue. Interim order pass earlier, shall continue. When next date?
Along the manner, 22nd.
22nd.
38.
Search sheet has been returned.
Search sheet late. You want in 438. What happened earlier? Who are you? Let us see what are the allegations. Abdul Kalam Azad. What did you do? Walpara? Huh? Wrong. Abdul Kalam Azad. Okay. Okay, according you are Azad. So you advise, that is the allegation. Who knows whether advice or not advice? Okay, considering the nature of allegations so far relating to the present petition and perusal of the material, and after perusal of the material so far collected by the investigating authority, this court is of the view that okay. Search sheet against him also.
That is what we are not searching time.
Against you also search sheet file, are you sure? Huh? So if you have no structure, how can you grant bail? Any interim?
And here,
It is submitted that already search sheet has been filed being
this is number 251 dated 22/6.
2022/6/2023. In view of the aforesaid, the interim order passed earlier so far relating to the present petitioner, if is made absolute.
39.
Yes, madam, what is this? CD received?
CD not received.
CD not received, interim to continue, next date.
22nd line.
22nd.
42.
Who was the Sashid later on?
Started late. Uh-huh. Yes. No, search sheet has been filed. You are on interim. We'll say that till committal and issuance of summon by the sessions court is since 302. So till then your interim order will continue. Okay, that much. Search sheet being
Sheet number 60/23, address 28/6.
in connection with so PS case corresponding to PRC case number or GR case, something like that. GR case number 2023. So in view of the above is provided our executive till committal and sessions till then.
Item 44.
Yes, Devi, series there. You are on interim. Let us see what is the allegation first, then we'll go to CD. What is the vernacular?
The particular is
16?
16.
Huh?
16.
What is her statement? And that person who reached the place, according to her, a person reached the place. What is his statement? Let us see.
There are one with,
You are Deepak Topo. Deepak Topo's name she has also not
no,
taken.
no. We have given his statement recorded version and one suspected, accused was also there. We have also named some others, not his name.
Not his name.
I can't for all of it. And he is cooperating.
Case diary.
He is also considered.
Okay. Case diary. Produce. Case diary produced is produced. From the victim guard, it is seen that victim guard has not specifically implicated the present petitioner. In her statement recorded under section 161 as well as in the FIR itself. Considering the matter in entirety, including the material available on the case record, and also the fact that the petitioner has cooperated with the investigating authority, this court is of the view that no custodial interrogations will be necessary in the present case, so far relating to the present petitioner. Accordingly, interim order passed earlier is made absolute. They
45,
dispose of CDB returned. Okay, লিখে দিবেন। Yes.
Statement recorded lawsuit, statement lawsuit. Here says that, মূল নাম,
What is his name?
মোৰ লগত প্ৰেমৰ সম্পৰ্ক আছিল, আমি একেজন গাঁৱৰে হয়। The accused person, he will stay one night in the hotel, under her name. Then they went to somewhere else.
So what is her statement?
Her statement is that, he has confined her in a hotel, but he doesn't seem.
Okay. Considering the material so far
Here
collected,
recorded statement.
considering the material so far collected, and also considering the stage of investigation and the fact that the petitioner has duly cooperated with the investigating agency, this court is of the view that no further custodial interrogation is necessary.
46,
Here, file notice.
Okay. An interim, earlier
Interim.
interim. Sessions tribunal or magistrate tribunal? 120B, 302. Being charge sheet number
Searching number, lordship, 169/23,
dated,
dated 37/2020.
this is the sessions tribunal. After committal till summoned by the sessions court. Competent trial court.
47,
47 of the searching submitted, lordship.
Okay, sessions tribunal or magistrate tribunal?
Case number, lordship, 85. Dated, 85/23, dated 31/07/23.
Okay, this is magistrate, huh? Till appearance before the trial magistrate.
48,
48, lordship, we have received the city lordship, FSL was called for.
Okay. Any interim? No. When you have a talk with your,
Lordship, we will try, FSL will decide on the daily application. Lordship, in 14 seconds.
14 seconds. For case
49,
diary and FSL. huh? Yes, Mr. Priya.
First time, my lord, initially when I moved it, my lord, my receiving prayer was rejected at that stage.
Hmm.
Now thereafter 2 days has gone, today also they are trying to bring the case that before is trouble from. As because he's a person, his name is in the affair, he has been protected. I am in a similar situation.
Where is the affair?
Affair, my lord, is that also page 14. Only was, my lord, affair before BPC election on the last opinion, my lord. On 28th February 2021,
Hmm.
wherein one person has lost his affair, stating that there is mass irregularity without tender, work authorization giving, exorbitant rates and everything. And my name appears in the affair, my lord, the lower below, my lord. At number 3, my lord,
Silaram.
Sigaram Nagar, and number 2, my lord, Manoranjan Brahma, my lord.
Number 1.
Number 1, my lord, Manoranjan Brahma. He came before the number 4. He is handling the inquiry.
Where is that?
Yes, my lord. I come to that meeting on the. That is.
Page 39.
39, yes.
What is, this is criminal petition.
I'm sorry. I'm sorry.
Page 42.
Yes. 42. 42 is also with regard to another case, my lord.
This is Silaram Narjari.
That is by Honorable Justice Surana has been granted, my lord, at least 50.
This is another affair.
Yeah, another affair was there, wherein I went for quashing, and there is no corrective action, there will be no. That's the page 57 in connection with this case. Page 57. interim police station. And you need to the exhibition, you have to go after, go tender, all these things. I have annexed the tender documents, the supply order.
Yes,
I
madam.
have supply.
One last conclusion.
What last chance? You
Last time I
let him appear and get recorded.
I submit all the documents.
See, same FIR, one person is granted with reason. And the FIR is not specific that it is against this person only. The statements involves 1, 2, 3, 4, 5, and many others. Who knows which many others? I think he should get a protection. Okay. Heard Mr. A.K. Bhuya, learned counsel for the petitioner, also heard so. The present application is filed under so. Initially, this court by order dated 3/8/2023 called for the case diary without granting any interim protection. And the case diary was called for, fixing the matter on 25/8/2023. On 25/8/2023, also no case diary was produced. Thereafter, the matter was listed on 29/8/2023. On the same date also, no case diary was produced, and the matter was fixed today for production of the case diary. However, the learned additional public prosecutor submits that she has not received the case diary today also. Mr. Bhuya, referring to an order dated 19/9/2022, passed in AB 2742/202022, passed by this court, whereby another accused named in the same FIR wherein the petitioner is seeking anticipatory bail was granted interim protection, order dated 99, and accordingly he submits that in view of non-production of case diary for so long, the petitioner is entitled for the similar protection and granted to the co-accused. The learned additional public prosecutor has seriously objected to such submission and argues that the petitioner was not granted bail interim protection on the first date itself. Therefore, such prayer may not be considered at this stage. Consider the arguments advanced by the learned counsels for the parties. Full stop. This court is of the view that the allegations, there is no separate or specific allegation against the present petitioner, and the allegations made are similar against the petitioner in AB 2742/2022 and the present petitioner and some other accused. Considering the above and also considering the fact that even after repeated order, no case diary has been produced, this court is of the view that the petitioner is entitled for an interim protection. Accordingly, it is provided that case 59, see this RDS order, you appear before this court and release this matter on 29 for production of case.
50.
Yes. Anything received? The scan copy of the LCR pertaining to GR case number 2618/2018. People.
The same copy of the LCR pertaining to GR case number 2618/2018.
Requisition by this court under its order dated 7/8/2023 has not yet been received. The same is reflected in the order in the office note dated 1/9/2023. Accordingly, the registry is to forthwith issue reminder issue reminder in as much as the matter involves personal liberty of a citizen. List on. No, give earlier. We give, we don't give, there is a different issue. 29th.
51.
Yes. Any interim? No, there is an interim. Yes. In the event arrest petition, Dhammaji PS case. Huh?
They have not received the CD, you wanted to fix the event 2 o'clock. They will be.
No, because you are already the interim. On 18th, there is an interim. Shall appear before the investigation officer and all conditions are there. But the CD not received when?
10/29 or 29/9.
29/9 interim order pass out. 8/8 sile over date. Interim order pass.
52.
Yes.
We had 10 letters and 1 line of the document, right? But sitting was difficult.
What is the number? I also got an FIR. They also got an FIR member. My FIR was not registered. They are assigned to register. There's some legal influence there. And most probably.
Where is your FIR?
My FIR is in my case 19.
What is it? Page 18.
Everything is done on the site. I think relating to the parking of action from my first.
Okay, this is your FIR. Where is the FIR against you? You lost the FIR on 3/4. And they lost. According to incident took place on 2/2. Your FIR is not registered.
Okay. Let me report my statement. And now a top member to run this.
Yes, when can you have this CD?
They've already sent message for logic 13/9.
Let us have an at 13/9. 13/9. You have sent 1/9 also.
My statement.
We are not protecting for the time being. We see on next when are you
13/9.
13/9. On the prayer of the case diary, call for is not received. List this matter on 13/9 for production of case diary. If no such case diary is produced, this court may pass may issue personal appearance, issue order for personal appearance of the investigating. Just inform it, we are not passing it. If not, then Because there might maybe market process, human error. They- Along with the injury report, along with the injury report. Yes. Agar order to the Neopolis, scan copies call for not received. List it when earlier record this, as it must it involves a personal liberty of a person. 13. 39 scan copy.
29.
29. 29. What is the effort?
Page number 9. I'm taking that. Still will require because we made dual trial.
According to the learned session judge rejection order, she has specifically implicated him. Though she said, I don't have any objection, but that cannot be a ground rightly rejected. I will see the case diary. 376. May not be. That is not the only purpose. Purpose is that who knows that you have treated her, and she's saying that I do not have any objection. One hand, she is alleging specifically in both 161, 164 from your additional affidavit. And she said, I don't have any objection. Who knows that you might have treated her to somebody else? That's why we'll call for the case there. Item 7. That is, Madam will decide.
19.
How many days you are inside? 376. When? 19.
19.
Okay.
19 item 26.
What is the age of the victim? Okay, we'll see on 19.
26 Adam.
Left hand. Yes. Huh?
After something.
Okay. What is the affidavit for? Oh, that's case surprise. Okay,
It is the logic control on Lalit.
okay, okay, after supper.
For orders, item 54.
Yes. Huh? What is this? No, what is this application? Condonation of delay. Okay. Await service report in view of office note dated 31/7. 31/7/2023. And list after 4 weeks.
Item 55.
Okay. What is the issue here?
Challenge the order of the landed. Whether the landed doesn't deny to accept the bail bond of the bail order landed by season. That is the issue. Landed was landed bail by the season. Subsequently, section 6 of the contract. That is why now landed to accept the bail bond. Think of the adding section. That is the issue.
Any statement of the guard? Let us see for a last chance. Let us see. Okay. Steps was taken on 25th of August, 25th of September. No, that is not a problem, but it's a POXO. That is the difficulty. It was issued on 29/8, not 29/7. 8. So at least await service report, await for service report, and be list this matter on 1st of October. Is it working day? 3rd of October 2023 with an up-to-date service report regarding service upon responding number. We can have, but ultimately on after 4 weeks we can have some presumption and all. That's why 29/8 it was sent. Considering that 4 weeks is over, then that's why we have fixed it.
56.
The case diary call for is also not received. Registered to issue reminder. Yes, Mr. Kumar.
In this case, the bill application was disclosed, and the comment was asked. But in advance, this case remained pending. It is for implement of the comment as comment number 2. But in the order itself, it is reflected that the common party was heard beyond October time looking to the order ticket 25/8 of 2023. On the other hand, Mr. Ticket who was learned counsel for the comment. On the day, this application probably was not reported. So that's why this is only for implement of the comment number 2. And nowadays, in view of the divisions and question of the number 4,
Is it not POXO? Then it's not necessary in terms of High Court.
This will be disposed of.
Okay. In view of order passed on 25/8/2023, no separate order need be passed in this IA accordingly. This IA stands closed. In terms of order dated 25/8/2023, passed in AB 2725/2023.
So first point, item number 57.
Yes, madam, we are directed to have the copy of the case diary along with the SIT report. So you go through it, and when you want, when you just tomorrow, not possible. It will go after vacation or before vacation. When? 22nd. Okay. The case diary call for in terms of order dated 28/8/2023 is received. The learned additional public prosecutor page that she may be allowed to some time to go through the same. Prayer is allowed. Please this matter on 22nd of September in the admission column.
58.
I'm very sorry, my driver actually very
Okay, there is a recent judgment which says that even in absence of the petitioner or his lawyer, court can proceed and decide criminal petition and criminal revision on its own merit. So therefore, we are following that principle. Yes, you read some for non-maintainable. Why?
Because my lord, in the service, someone has been issued.
Hmm.
Against that someone, they have done. Charge has not there. He is not even APR. He earlier applied for bail was rejected, he was directed to apply to the court.
Hmm.
Without he appearing the court, my lord, they file a personal petition. He is not, such has been by showing him as external government.
Where is the impugn order?
Because I have come for possibility.
No, you said that quashing and impugn charge sheet dated 30th. Okay. Where is the charge sheet?
My lord.
How you reach your driver met with an accident?
No, yesterday, when he was coming to my chamber, my lord.
Okay.
Suddenly he met an accident and he said.
Oh, these kind of things are frequently happening to you. And more particularly when old methods are listed.
That is not a problem. They said, I had you, madam.
That is the problem. But I know you have a habit of burning midnight candle.
This is a picture. And what picture is also doing the art to do. So, Lord, particularly only on human law, nobody, here.
No.
There's 120. I have to do a lot of things for you.
That is your greatness.
There's 120 plus someone, my lord, that someone has been excellent. That is the right one as responder. Before that, he applied for NDC as well. It was rejected. You are directed to the boot below.
Where is the FIR? First FIR. Or you are totally handicapped. So tomorrow.
Tomorrow, on Tuesday, otherwise, tomorrow, will have to shift it.
Shifted to tomorrow, day after tomorrow, you may have an air ambulance, then also there will be a problem to take him to AIMS.
I cannot just avoid him, because there are
No, you cannot avoid that. We are correct, but we also it's difficult to avoid cases of 2019.
I am, and that will be, so then take up the matter on Monday.
13,
I'm okay.
but no further adjournment. Huh? If you are busy with your driver, the petitioner will either have to arrange some lawyers or will take on its own merit.
I'll do that. Very beginning. Several observation has been taken.
And you are always successful, I say.
Not maintaining the Indian Supreme Court decision, because it is a matter of the constitutional party, relation to based around in 2014.
Then you are ready, let us proceed with this, yes. You are ready, without the file you are arguing. Okay, on the prayer of Mr. Purkasta, the matter stands adjourned and be listed on 13/9. Full stop. No further adjournment shall be made on the said date.
I think 59 to 63.
Why so many revisions?
On FIR and for complaint.
Complaints. Okay. And some suit also.
And it is also mentioned.
Okay.
Now the first is Taken 154 of 2021.
Just let us have an overview of all the cases, what is what, because arising out of the same fact that allegation of fraudulent execution of sale deed. One suit is for declaration and cancellation, and this is that somebody has not executed the sale deed itself. This is the case. And just tell us item number 1, what is this? What is under challenge?
Item number 1.
Not one item number. First item 57.
154 of 2021.
Yes.
This is a case in affair.
FIR
dated 13/12/2020.
13/12/2020.
By
Any leftover matters? Ready? Okay, just give me a minute. We'll just finish that leftover matter.
23.
Okay,
केसरी हुए अब मैंने इस पर्सन को आपका भी इंटरव्यू लेटर दिए थे किया दो इट इज नॉट सेटेड फॉर द केसरी
this is the affidavit. See, what happened is, earlier also this stand was taken that he has not appeared. Then he took a stand that no, we have appeared 3 times, no statement is not recorded. So this affidavit is filed. Now we are thinking of proceeding, because in terms of Honorable Apex Court, there must be CCTV.
Right.
If this kind of situation arises, we will not spare the investigating officer and we will have the CCTVs. He made a specific statement. That's why we wanted this affidavit. At paragraph 4, he specifically stated these dates. You go through it, have instruction, and if necessary, the IO is to file a reply to this affidavit. Then we'll call for the CCTV footage. Are you on interim? Or that's why you went it. Okay. Though it is submitted by Mr. Borua, learned additional public prosecutor, that nothing is reflected, whether the petitioner, nothing is reflected in the case diary, whether the petitioner had appeared before the IO in terms of its interim order dated, in terms of the interim order passed by this court on 24/20/2023. In this regard, an affidavit has been filed by the petitioner stating the following, paragraph 4, quote, full stop. In view of such specific stand, Mr. Borua shall obtain instruction if the petitioner has appeared before the IO on 3 dates, whether his statement is recorded, and if not recorded, the reason thereof. List this matter on next Friday, give Fridays, 15th of October 2020, with a copy of this order be furnished. No, I'll say that Mr. Borua may download a copy of this order from the website and furnish the same before the IO for necessary instruction. Interim order passed earlier shall continue, and petitioner shall be at liberty to again visit the police station to get his statement recorded in the meantime. Yes, Mr. So 57 is FIR, crossing of FIR. FIR dated 13/12/2022. Son of the seller.
One of these sons has filed it.
Okay, then what is 58?
152/2021.
Yes,
This is the complaint. And the CR case number
3 of 21,
filed by nephew of the, nephew of the same.
nephew of the seller. Okay. Now, nephew of the seller. It is CR case. Cognizance has been taken.
Because filed on 4/1/2020.
412021. Then 59.
59 is, calendar is on 153 of 2021.
Mm.
So here this number 314 of 20.
314
4 of
20.
filed by
Uh,
the seller and the,
mm.
oh, sorry, son of earlier, Abul Hussain, son of earlier, one another son. The same son who is filed the FIR. Filed on 10/9/2020.
10/9/2020.
This is the first case.
Okay.
When the same Abul Hussain filed the court case, they are 2021.
Item 60.
Item
60. Yes.
156 of 2000.
CR.
Filed on 4/1/21.
CR number
They are 2 of 2020.
2 of 21 filed by
Filed by Abul Hussain, son of earlier.
another son.
The second son who has got the FIR and we have filed both this complaint.
So son lost 314 and 2 of 21.
Yes.
The nephew lost CR 3 of 21.
3 of 20.
And the son again lost an FIR on 13/12/20. That is 50. These are all 61.
157 of 2022.
What is this?
This is complaint filed by the seller. Here case number 458 of 2020.
458 of 20,
Filed on 11/12/20
11/12/20 by
by Ali Akbar, the seller.
seller.
Now, all the other FIR and the three complaint case which are against the petitioner, people who are watching,
You are the purchaser.
and the purchaser.
And who are the who's according to who so executed the sale deed?
Criminal exhibit by Ali Akbar.
The seller, that is who lost either that CR 458.
458. Now, 458 is not only against me.
Hmm.
This is against petitioner's son,
Hmm.
one of the sons,
Hmm.
then sub-register,
Hmm.
then circle officer, then Mandal, Mursi of Kotua police station,
Hmm.
investigating officer, and another son, and some officer.
Okay.
He has launched this complaint against these towns and coming from on the ground that there was an inquiry conducted by the complaint staff. And in that inquiry, they had given statement which they were.
Okay.
I will come to that. So this is against my name. But the first four are against.
So your argument will be decision abuse of the process.
This is the abuse of the process of the court. Secondly, there is a civil dispute already we have completed. And there are no materials to show that there has been already on presentation. And inquiry was conducted by competent officer, and after conducting by inquiry and taking evidence from different sources, including his own son, it was found that he is true.
Okay. Okay. So which method should we take as a prime case for
This is the first case.
that is 154? Okay.
Now,
The last case is 4/1/2021, nephew of the seller. Isn't it? First case started with the CR 458, 11/12/2020.
first is certain.
Seller, by seller.
No, first it was by one of the sons, 314 of 2020, it was by a son.
On 10-9. Okay, okay. 10-9. Abul Hussein. That is 10-9. Then 11-12 by seller. Then 13-12 by son FIR. Then 4-1-21 by nephew. This is the sequence.
Yeah, it is really good. Yes, first this is given division 150 plus 21. Second will be 157. Third will be 154. Total division.
Hmm.
Fourth will be 156 of 21.
Hmm.
And the fifth will be 154.
Okay. So we'll have our hearing in item number 57. You have prepared in item number 57. Okay. Huh? No, 57. In 154.
First,
154 is the first case.
first is levels. 154 is my item number 59.
59, that's what. 59. 59. Nine, 60, 61, 60. Okay. Just let us again verify. FIR 13-12-2022 is CRP 154. Is not it? The revision 154. Then criminal CR3 of 2021 is 152. 152. Then CR314 is 153. Then CR2 of 21 is 156. And CR458 is 157. 57. Okay. Yes. Just a minute, just a minute. Page 22. 211. This revision is filed by Miriali and others, not only Miriali. The son and father son. Okay. Yes.
Council police station. I paused here for a while. The land is sold. That is sitting in the jurisdiction of the court.
Okay. But filed in
Filing Council police station.
what did Kampur do? They proceeded with investigation or transferred it?
Investigation is that the police station did not. If they are very clear for the filing. They file there.
You have not, therefore they file CR cases. Or what? Why these CR cases and all these CR cases, FRAS, why? What is the reason?
Have categorized all cases into two categories. Your object finding
Okay. Let us complete this hearing, Mr. Chaudhary. Then we'll come back. You just note it down. These are questions coming.
government is highly ultra dated 82 years.
Hmm.
It was very easy on that, I'm sure. The user, one of the value, the particular major value is son. Kumar Padra, after Mr. Pangu, Sangita Padra, Counsel, Circle Officer, Usi Bora, second officer, Super Police Station, Ramananda Bora, the chief writer, the chief signal. Sir, only say, informing that development and land is my own land. Having right that is implied and the allotment and repeat persons in my absence from 13/10/2020 after forging my signature to sale permission and in my absence executed registered duty and thereafter it was mutated to the name of the first accused and without any order from the government on 1/11/2020, petition for 1 and 2 with a game of Bundas comprising 22 persons unlawfully entered into my house and threw me and my family members out of my house after beating us and as such captured my house. For such illegal act of petition number 1 and 2, I have tried to lodge and written after the local police station. However, the second officer of the concerned police station misbehaved with me and kept me in the police station for the whole day. And about 5 p.m. after taking an amount of 25,000, I was allowed to leave the police station. In the deeds executed on 13/10/2020, only in some places my signature has been put. There are some signatures I did. However, in every place my signature has not been put.
No, that he has said 13/10/20 তারিখে সম্পাদন কৰা যোৱা দলিলবোৰৰ দুই এখন দলিলতে মোৰ দুই এটা সহি আছে উইদিন ব্ৰেকেট জাল সহি যদিও প্ৰায়বোৰ দলিল পাততে মোৰ বিক্ৰীদাৰৰ সহি নাই. He says the signature, those two signatures were also four signature, and in other pages there is no signature.
Registered was only after Tonova
মাৰ্চলৈ কিনে বা কোনোবাখন আগষ্ট মাহত কিনা দলিলবোৰ ভালদৰে পৰীক্ষা কৰিলে এনে আৰু বহুত তথ্য ওলাব.
বেআইনিভাৱে সম্পাদিত হোৱা দলিলবোৰ আৰু 1 নম্বৰ আসামীৰ নামত হোৱা অভিযোগৰ নামভৰ্তিৰ সদস্যৰ প্ৰতি এই সাধাৰণতে ৰাখি দিয়া হৈছে. এই বস্তুবোৰ সংগ্ৰহ কৰিছে সময়ৰ প্ৰয়োজন হোৱা গোচৰ কৰা কিছু কলমবোৰ তদন্ত সকলো বিদ্যালয়ৰ প্ৰধান দয়া কৰি তদন্ত কৰি চিকিৎসা কৰাৰ
Okay, this is the affair lost on 13/12/2020. No, 13/12.
In one place it is 13/12 and this is 216 or 13/10/2020 at page
13/10/2020, yes. ET 13/10/2020, but in above it is written as 13/11 or 2020, something like that. First page.
page 1 if you are will find
13/12/2020. Received and registered.
registered on 13.
Might be just filed on 30/12. FIR is written on. Okay, anyway, we'll look into that later. Okay.
Now, there are two agreements also.
Now, charge sheet has also been filed in this case, or what? Stay, okay, okay.
Because
Okay.
now, there was an agreement for sale.
Hmm.
There were two agreements
Hmm.
for sale of two pieces of land.
Hmm.
One is a pata land, the other is a annual pata land, both the money land.
Hmm.
Now, the first agreement, the worship will find it page 22.
Case?
22.
Yes.
It was an agreement between the petitioner and the seller,
Alias, sir.
the other. It is 2/12/2019.
FIR was by alias, but isn't it? Page 215.
Yes.
By seller.
This one is by seller.
Yes.
It is an agreement for sale of June 2019.
Hmm.
Yeah. It was it.
Total 10 bigha, 1 katha 9 lakh. 32 lakh 7,000. Hmm.
Here, at page 25,
Hmm.
one of the witnesses,
Hmm.
Guru is coming,
Hmm.
is the son of the state. Guru and number one. Guru Nabi, Ita Ali Abdul. The other agreement
Hmm.
is at page 29. This is a registered agreement.
Page
Page 29. So the agreement for sale of Pata land, measuring 3 bigha, 1 kata, 12.5 lakh. In the agreement, Guru Nabi, the son of the state, is a witness.
Hmm. This land and the land mentioned in the FIR are same.
But if you
Just one thinking, just it's not, don't think it to be a comment on that. Will the investigation not help you? No, it's just the thinking. Will it not help you? Suppose these are sent for forensic report and it comes that this is the signature of none other than this person who lost the affair. Everything is gone.
that is one of the
Just looking at it. Because these are the registered documents, harm impressions are there. Only thing is to be done is to say, take a sample of this person and send it to the investigation. This will help. In fact, in the title suit, They will require to do this because they have made an allegation that this is not my signature.
That was what I was about to say. And secondly, this was done in the office of the surveillance.
Hmm.
And the inquiry has been conducted by them. Given opportunity to the seller and all others connected to any evidence. If the seller, once he appeared, he said that I am sick or on some ground he is taken employment. Then there was how it was agreement against he did not come. But with some came and others came, they have this mistake. And it was done in the office of the surveillance. Yeah, it was conducted and surveillance. Therefore, at least for this union case, for them, there is no Page 23 or to find their signatures.
Page 32,
32.
33. Yes. They are silent about disagreement in the affair. Which are registered.
This is the
Okay.
there is deliberations that means document.
Sir, these are not our signatures. But suppose just we are taking an overall, we will hear in detail. Suppose there is an agreement. There is every possibility there, every scope of even cancelling an agreement. Both parties might have right in terms of the agreement. Just a wild thing. Now, suppose agreement is genuine, but sale deed is not genuine. Can't it happen?
This can happen. In the FIR or in the complaints, however, there is a
That is there. Why they are silent?
because that shows the
Abuse of the process. That's why I first asked that is it an basic ground is abuse of the process. Anyway.
Satisfy your lordship with the document that there is no financial verification charge.
Okay, proceed.
Then there is
Since we have enough time, almost list is over, so we can patiently hear it.
nothing much. Then the petition and made payments.
So I can ask him to go for some time. He can do his work.
I have anything agreements.
I have seen that.
Then also photograph when the transaction took place. And this is what is the time complete. So 38. Then page 41. In the advance of the photograph of the day. On the page 41, we signing this. This is the seller of the Rabi. Then the other
Hard case.
these two, one with the black shirt is the son. He is the son-in-law. And he appeared before to the priester and said that it was signed with my presence. Another son, that will be quite right. Then below will be the son. And the
Who
one
is this
which,
with cap? White cap cricketer. Who is this cricketer? Huh?
white community,
Okay.
they were sitting disappear. Sitting in December, sitting on the table.
Yes.
So they were so close that they could sit like this. And money was counted in this 14.
Hard case.
Which is founded by Iman Ali, his son of Ali as well. And thereafter, sitting on the
Red chair.
being the sailor and you're just standing here or you can see the I was just wondering why these photographs were taken, because there was some suspicion that this man become busy. Otherwise, normally this photograph are not taken.
Ah,
So his intention was perhaps suspected from earlier, maybe, whatever, and that's why I was saying.
now who is in the possession of the land? And what is the stage of the suit? Hmm.
Then there, we are watching me, something was filed, something is not understood, that was forwarded, by the ADC to the survey officer. That is 66. So 49,000 ADC has forwarded the petition submitted by Mohammed Abdul Hussain. It refers to the subject secretary and the petition and investment submitted by
Just a minute. Hmm. Okay,
there were two, three complaints. This 68, what you will find the complaint filed by others. Page 68, just to the ADC, revenue. আবেদনকারী মোহাম্মদ আলী পাত্র আবেদনকারী পুলিশ বিভাগের এই নয় উপরোক্ত ঠিকানার একজন একাকী হোটেলের দুর্গণের পর এসে নয় অন্য মিডিয়াদের উপর 1 বিঘা মাটি বিক্রি করেন বলে তেওঁলোকৰ এটা বাইনামা করেছে কিন্তু মোহাম্মদ মিডিয়া দিয়ে মূল সূত্রে মূল নামক লগতলৈ মূল বেশি মাটি ও মূল নামৰ অন্য মাটি বেচা কিনা কৰাৰ বাবে এটি গোপনে আৰু সক্ৰান্তমূলক ভাৱে উল্লেখ কৰা বেচা কিনা নম্বৰৰ জৰিয়তে 28/2020 তাৰিখে অনুমতি উলিয়াই ল'লে অনুমতি উল্লেখ কৰা মাটি মই বিক্ৰী কৰা নাই গতিকে মহোদয় দয়া কৰি বিষয় উল্লেখ কৰা নম্বৰৰ মাটি বেচা কিনা অনুমতি তলব কৰি বেচা কিনা পঞ্জীয়ন বন্ধ কৰা প্ৰথমে জনাব। This was also forwarding the ADC to the survey officer. Forwarded after 69. Forwarded this complaint to the sub-register. This 72 even notice. Notice was given. With reference to the letter number 20 of the second notice, earlier there was a notice. The second notice has been issued to Muhammad Ali Azhar, son of Muhammad Ali of resign from under group of Mota of Counsel regular circle, is present before the sub-register, Sambo and the sub-register, and medical officer Counsel on 59/2020 of 4:30 PM for a hearing against the petition submitted by him for copying the registration of the their number and the number of then another notice. These are all notices. The prosecution can be reached by 76. With reference to the letter number which was dated 11/9/2003, which is third and final notice has been issued to Muhammad Ali Azhar, son of Procedural. To be present, it was sub-register Counsel at office of the sub-register, Register Counsel on 12/10/2020 for a hearing of the petition considered by the registration of the
is anybody is representing the state? Any record of this sub-registers record? No, else there will be no LCR as such, but we want the record that is this notice was served upon him. Huh? But registry what case there will reveal what? To say, see, ultimately the case revolves around that three things is there. One is he admits that there is an execution of agreement for sale. He has not denied. But what is his case is, according to that I agreed to sell this plot of land, but in collusion with my son-in-law, so and so has been executed, sold. I have not sold it. This is a case. Whether that is correct or true will come later. Now, he lost that complaint. Yes, I have agreed to sell this portion of land, but not this. And no objection certificate has been issued in respect of this land. Correct, wrong will come to a little bit later. Now, sub-register rightly has taken, okay, there is an objection, we'll have to hear it. Notice is issued, first notice, second notice, third notice. Final notice, sub-register says, see, we cannot wait anymore. If you want to come, you come, or we'll proceed with the registration. Now, whether that notice was received, whether served upon him, that is a very important issue. That is, yes. No, argument is different because see, here is two things of case. First questions will be so many CRs and so many criminal cases. His argument will be already there is a civil suit pending. You filed a suit for declaration of right title interest and in cancellation of sale deed. So in that case, your rights can be protected in a civil suit. Now, so far coming to the criminal case, your argument will be that two parallel proceedings can go on. Civil suit is a different subject matter. I want recovery of land, cancellation of sale deed, and a criminal case is alleging a forgery that my signature, this is not my signature. This is not my signature. So for that, basics dispute starts with the NOC, because your admitted case is that yes, I have executed an agreement. So the agreement is there is no dispute on that. Your case is that this was you file a complaint, you have not appeared. If you have not you have received notice and not appeared, why should we proceed with the criminal cases? You get your decree. This may be one view. Other view is that possible it is that he was not even aware, he was not even received. That statement is required. Mr. Chaudhary is correct. That affidavit is required because when it's a allegation of abuse of process, certain facts are ascertained even in a revision petition. Why abuse? Abuse, determination of abuse of the process. That is on what we can two part. One is making a prima facie case, and other is abuse of the process. When it's abuse of the process, he will specifically make a statement that this foresee his conduct. This is the abuse. Now, whether you have received that notice and you have not appeared, you owe an explanation. What is your stand?
I have categorized 152 and 156. If the lordship finds criminal petition 152 and 156, allegations both are different.
No. You forget about other cases. Let us concentrate on the first case.
154 and 157, I have categorized it that same complainant has filed one complaint case and one file. Now there will be reason behind it. The FIR was launched on 15/10/2008 because of register.
Hmm.
And thereafter, they have went to the complete court and find the complaint case with the same set of allegations.
Hmm.
And that can be taken care of unless they have to provide the provision of 210.
Hmm.
See, now 153 and 156 criminal petition law. These are by the same complainant, same allegations which are already there in 152 and 156. So 153, 156, I'm not so very not pressing it for it. This.
But in the meantime, that has been dismissed for default, though there was a stay. Anyway, that will look into, that it will not treat it as to be
Now-
dismissed for default.
Now, Lordship find. What are the allegations? in
Now,
the-
tell me, just answer my question.
What is
We'll
the
go to
allegation?
the
What is
niceties
the
and the
allegation?
merits a little bit later.
What-
What is your answer that whether you have received this notice?
No, Lordship will find it.
Page
It will be-
80.
Receipt this and this is verified. Unless there is a denial. So this is also not my
Signature.
The court is revealed by the court.
Yes. For us, or what to do?
So lawsuit files in anyone of
Hmm.
the allegation in the FIR.
No, allegation in the affair makes out a case. No doubt on it. No doubt on that. That is, I have not signed. Yes, status specifically, I have not signed.
And the other thing that in some of the stated papers, like the stamp paper, the seller signatures are not.
So your argument will be that is a matter of investigation. Court should not stall the investigation. Let the investigation go on. The result, if it is my signature, it is my signature. If it is not mine. This is your argument. We understand that. But at the same time, there will be a question of abuse of the process, since that will be one of the plank of argument. That's why. Otherwise, if it is only a case that no case is made out, according to us, case is made out. Right, wrong, we do not know.
And to my humble
Specific,
opinion,
I have not signed this agreement. So he is bringing abuse because you admittedly entered into an agreement. You raised an objection that, see, I have not, I have agreed for this part only, not this part. Then there was a notice issued to you. You have not appeared. Then a decision was taken and deed was executed. So there was no criminal intent on the part of the others. Where is the criminal intent? You could have said that, no, see, this is not. So they have executed a sale deed in.
These are the documents, these complaints and the objections are with regard to before the sale deed was executed. It was a complaint that the sale permission should not be issued.
Hmm.
The allegation in the FIR to lawsuit finds that is only with regard to the execution of the sale. That
Understand?
my signatures are put. So the investigation which I have said in this software initiative, that is.
Understand,
that
your
is-
whole plank is that you read the FIR and look into whether case is made out. And that issue has been raised by me earlier also. Saying that, yes, I entered into an agreement. I have not denied the earlier agreement, but but sale deed has been executed by forging my signature and the NOC has been issued by my signature. So therefore, no further things is necessary, whether
And you also will find the criminal petition 152, the complaint of that complainant. What is his allegation in that? His allegation,
is that this is my land is sold by some other. I was not a party to this agreement.
in criminal petition 152,
Hmm.
the complaint you also will find at page 229.
Hmm.
His allegation is that page 230, the second page. That is his.
Tell us, just, I want to have just overall view of the matter. Then we'll go in details.
My
We have time.
my photo and my signature, which were used in the form for obtaining land sale permission as a co-partaker of the same land are also fake and counterfeit. How could the accused obtain land sale permission without taking my signature? In addition to the office of the sub-register, the local revenue or circle officer is also involved in this fraud.
This is by whom?
This is by Mohammed nephew. Nephew.
How nephew is involved? According to nephew, that he is also co-sharer of this land.
Co-partaker.
Co-partaker. Okay.
Taking a for the FI also does not say, and here also there is no deny that we have received the amount. Received amount from you. Although the money was given, that is signature account fine. That is also not the eligibility. So admission is that admission is where when he has to complain to the ABC. Here he says that I signed the agreement.
But not in respect of this land.
Of the same day. What about the money receipts? Because those are all one next day. Here also that is not denied. So there is no denial that there was an agreement. There is no denial that if he has taken out the money. There is no obligation that signature obtaining the money is also not mine. That is not that the FI. That is not the therefore, one of the worship made us see the intention to malafide because they have to satisfy the board that there is this fear on the part of the particular individual worship. The documents will speak for themselves. These are all clear, and the delegation is not only against me. The delegation is against the officers who are visiting the office.
The officers have not come to this court.
And they do know that
More than they should come. Sanction is there. Many things are there. If they have done all this,
that they affect their service period also.
yes.
They know the fact that nothing will come out.
So we'll continue at 2 and finish it up. Necessary, we'll make it CAB because many facts are there that cannot be possible to dictate. I see.
Eight.
Yes.
Because the petitioner has promised the informing of to marry or not.
And married.
No, lordship.
Yes.
They have only applied for the marriage lordship, but on the day of solemnization of marriage lordship, the accused lordship did not turn up. And subsequently, lordship, he took transfer from his place. Intended to marriage lordship. And his son.
So he expressed his intention to marry. Where is the question of shipping?
Lordship, in the
There may be some misunderstanding. He thought that okay, better instead of having a divorce after 1 year, let us not continue. So his intention that he will marry you is clear from this.
Yes, lordship.
But he withdrew because maybe for this leaving all this apart, this may be matter of trial. What is the purpose of keeping behind him bar? He was arrested on 1980.
So the explanation of being carried up of this.
We'll come to that. 1980. What purpose will be served if he's kept inside jail, except your happiness that he is in jail? Isn't it?
No, not actually happiness, lordship. What thing, lordship? Is some of his employees are threatening me, lordship, that I should withdraw the case. And to that extent, some of his friends have already started posting several things in Facebook and Instagram, lordship, to which now it is difficult on my part, lordship, to come out of my house.
Highland affidavit tomorrow. Highland affidavit tomorrow, stating all this and bringing all this on record. We'll deal with you. Be there for 2 more days.
Only thing is, regarding whether after completing the pay, we will estimate of that part, but it is a.
No, specifically he has already submitted that there is a threat.
Statement on the subsequent FIR will be there, lordship. And in regard to the proceeding part and all of it, it will not come with this case law. It is the condition of the bail law. Cancellation of bail law.
See, everything is there. Ring ceremony was there.
And ring ceremony also two times lordship. Ring ceremony 2 times.
And they
Last
allow
time at the place of the informant, thereafter lordship, we have demanded a amount of rupees 1 crore, and he stated that I have to feed my local person from my village, so he will have to arrange everything. And as such, so under that, his saying lordship, the accused has sorry, the informant has arranged that also in the case of the accused lordship. Already 2 lakhs has been paid to him. With a promise that I will pay another 98 lakhs when the mother of the informant got welfare, and the mother of the informant suffering from cancer also.
One part of it, even that it was not there at the time of it, that I took about some time ago, I did, partial of it. Before paying of it, they have paid of it, that the election making the FI of it, that time they should stop of it. That is not a good man of it, of getting some money. And locally kindly come to place 23 of it, the FI of it, the individual, this is 2% of it, but you can place 23 for a second.
She's a doctor.
So she is pursuing her various courses in final year lordship.
Let her pursue the final year. Forget this man.
Lordship, for a moment, lordship, lordship said page 29 of the petition lordship, the order of the land trial court, where the trial court has also stated lordship. In the
Case there is there. Case there is there. Huh?
Can you come to page 20, the conduct of the informant, can you page 23, the last page of the file of it. The conduct of the, it is individual, it is 2 individual, copy to chief minister, copy to DCP, copy to SP, that is the conduct of the informant. What you tell me page 23, the original copy of the FIR.
What are the offences registered?
So if you mainly look after, if you go to the sessions and order of the clinical of the case there is option, that on page.
case of the page 25 lordship, 493, 420, 387, 506, and later on also 376. Because under the promise of marriage,
Page 29.
Madam, when can you have the case there? Nalbari is only 1 hour. Monday. Monday. You wait.
Order of the sessions.
See, generally in a 439 case, we call case the call diary, call the case diary. In this case, since he has made certain objection, let us verify this. We are already more than 30 days.
20 days. So 20 days or 90 days.
Huh? 98. 98.
Regarding the part of the investigation of it, that is already been completed. And
That we can say only after going through the city. Let her be happy for 2 more days. On Monday, Tuesday. If no CD is all received, we will allow it one day. 12/9. Yes, and if you want to file anything, you file it, and you have no right to argue but to assist.
Yes,
and remind yourself that you cannot be privy to the case diary.
Yes.
Yes.
I will undertake to.
Okay, then we are in the inquiry report. Page 77. Okay, where are they? He's a son of the seller.
Here to say that it was decided that my father, Ali Ashok, son of the resident of Katika, is Nova, will save you entire land and the blood number to Miri Ali, son of late the resident of Guwahati, at a rate of 3 lakhs per year. An agreement for sale was executed between my father and Ashok and Miri Ali and registered on 2/12/2019 before the transaction concluded. Being number 13, for the sale of the land, there is job number 170 and 160 on the part of the I was the witness in the same.
Who is Ali Asgar? And this is the son-in-law. Now, why it is said that my father-in-law Ali Asgar have received an amount of 41 lakhs?
No, that is the 383 is the second.
I am at page 83. Okay, 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 okay.
In line, so decided that my father Ali Ashok, so and so will stay in the entire land to Miri Ali. An agreement for sale was executed between my father Ali Ashok and Miri Ali and registered on 2019 before the subject concluded. Gate number 13. I was replacing the same thing, the second task, and the signature and administration of only coordinator through and correction training. Another agreement was also executed by Adiosher in favor of Miri Ali for sale of land bearing number 13. I was also the witness to the same agreement, and that all the signatures in the same agreement.
What is the sale deed? Have you annexed the sale deed?
Sending your property under page 91.
Okay. This is the sale deed which they want cancellation in the even a civil suit.
For 2 months. That will be helping. The second is, only after signature is not there. And this will be a ground for him to call cancellation of the same date in the civil suit. But the registration is not designed with 50 bills or only 10 bills. just 35. Two 40%.
Mirial is the purchaser. You have the back page of this. That is very vital.
You can put it within 35. So they become so low enough, they have to reduce it.
No, understand. So your basic case is that deed was duly executed. The two witnesses in an inquiry made statement that this was duly executed by the executor, the seller, and therefore from the material available on record, it is absolutely an improbable thing that he has not put the signature first, and therefore no case is made out because he himself has said that this is the agreement I entered into. He has not denied the agreement. He has not even appeared before the inquiry thing, and therefore, and if you take look into the facts in its entirety, it is a abuse of the process of the court and to harass you. This has been filed. This is your case.
This can contain that. One FIR for complaint to the enough. Because the transaction is one.
Transaction is one.
And there are.
So suppose we say that case is made out, then of course all these proceedings cannot simultaneously proceed. Either it is be taken as 161 statement or to be clubbed. That aspect we can take over, provided we hold that there is a prima facie case will not interfere. Then only if we quash it. One quashing we will go everything. And if we do not quash, say that no case is made out, then the remaining cases can be treated as the 161 statement to be taken during investigation.
There is an FIR. There are some details. And the documents that I am relying on, these are not part of the investigation. Therefore, would you also have to rely on these documents? Because these documents are not controversial. This is important. Because they have not filed any affidavit saying that these documents are all or this is not my signature, I have not received any money.
No, he will argue in that case that my FIR itself I have specifically stated that I have not. It's a matter of investigation. If this is my signature, you filed him against a case against malicious prosecution. Because I am thinking, suppose there is an investigation and you are correct. That will help not only you in this criminal case, but also in the civil case. Why should you face an investigation? Yes, that this is a false case. False case. Okay. We have no problem on that subject to further argument. That there is no quarrel on that. Recent judgment has come where it has been said that while exercising 482 power, court is to be more cautious because when an FIR is written with a false intention, it is more properly drafted than a automatic and genuine FIR. This is the judgment, paragraph 13. I relied on some judgment day before yesterday by my Lord Justice Pardiwala.
I'd like to submit to that. Besides the FIR, I have placed documents to show that money was these are not disclosed in the FIR. Because the FIR also had disclosed info on that the agreement was executed. This is not in dispute. Secondly, the phone has not, the phone number 2 has not come out. You can be free. Because I have not received the money. I have clearly shown here by showing the whole that the money has been received. Full compensation amount has been received.
So it is its intention is not good. It shows his intention.
Yes.
This is,
And what I want is that these documents, which are not part of the investigation, Supreme Court says that we have objected to these.
Supreme Court says,
Question may come, because these documents are not before the investigation, not before the case report of all the complaints. This may be one to nine, that may be. The thing that I tell you is,
okay. He will definitely say, see whether this receipt is genuine or not. This is a part of investigation. Let the investigation be there. They may give a final report.
to counter that,
Yes,
because this question may come to your.
yes, that it's coming to my mind. That's why I'm saying why, okay, he made a specific allegation that these are not my signatures in the cell bit. He said, I entered it. Okay, not stated in the affair, not stated in the. But he will, in reply, he'll argue, and fire is not the encyclopedia. My statement is recorded, I will say, it. This will be his argument, isn't it? Huh?
2012, volume 9 SCC.
2012, 9 SC. Paragraph,
2460.
paragraph,
Amit Kapoor.
Rameshan.
Paragraph that I'd like to read is the Vasu Pandit, paragraph 13,
Paragraph 13,
18,
18,
20,
20,
26, and 27.
26, and 20.
Starting with paragraph 13, 18 and 20, the textbooks are important. That was going to be discussed. But I'll be more arguing on paragraph 26 and 27.
Okay.
Paragraph, let me read out this paragraph. Paragraph 26.
Yes.
This further raises the question as to the wrong to become actionable in accordance with law. It can be purely a civil wrong or purely a criminal offense, or a civil wrong as also a criminal offense, constituting both on the same set of facts. That is what is happening here.
Yes.
But if the response disclosed commission of a criminal offense and the intelligence of the offender satisfied, then such criminal proceeding cannot be quashed merely because the civil wrong has also been committed. The power cannot be invoked to stable or stumble a legitimate prosecution. The factual foundation and ingredients of an offense being satisfied, the court does not either dismiss a complaint or quash such a proceeding in exercise of its inherent or original jurisdiction. In Indian corporation, the court took the similar and appealed the order of the High Court declaring the part the criminal proceedings because the civil contract between the parties was pending. No, paragraph 27. I think describing the scope of jurisdiction under these three provisions, that is section 397 and 482 of the code, and the fine line of jurisdiction and distinction, now it will be appropriate for us to analyze the principles with reference to which the court should exercise their jurisdiction. However, it is not only difficult but inherently impossible to state with precision such principles. At this, and upon complete analysis of various documents of the court, we are able to allow some of the principles to be considered for proper exercise of jurisdiction, particularly with regard to quashing of charge, either in exercise of jurisdiction under section 397 or 482 of the court, together as it is needed. 27.1. There are no limits of power of the court under section 482 of the court, but the more the power, the more detailed and possible to exercise the power. The power of quashing criminal prosecution, particularly the charge taken under section 222 of the court, to be exercised very sparingly under section. Then 27.2, the court should apply the case as to whether the uncontroverted indications are made from the record of the case and the documents submitted there with prior of the side establish the offense or not. If the indications are so patently absurd and inherently improbable that no prudent person can ever reach such a conclusion, and where the basic ingredients of the criminal offense are not satisfied, then the court may interpret. And your worship, this we can come to paragraph 27.1. In exercise jurisdiction under section 228 and or under section matters given by an accused for reaching the conclusion that no offense was disclosed or that there was possibility of the acquittal, the court has to consider the record and documents connected thereof by the prosecution. Washing of a charge is an exception to the rule of continuous prosecution, where the offences even broadly satisfied, the court should be more inclined to permit continuance of prosecution rather than its stopping at this stage. The court is not expected to marshal the record with a view to decide admissibility and validity of the documents on record, but is on option an option on decide. Where the charges, this is not present.
Not really.
Now, these documents are going to be
More particularly, you will rely on 27.2. That you have marked it.
more decision. Because this question will come by the way we can go. So my round of statements in all these cases
Hmm.
is that when there is a civil case pending,
Hmm.
civil proceeding is pending, filing of several complaints against the petitioner by seller, his son, his nephew, is only to have a legal. A civil proceeding is pending, so many cases have been filed.
Hmm.
By the seller, his son, his nephew,
Hmm.
only to have.
Hmm.
Then the statements in the claim.
Hmm.
I'll draw your attention to some character, which is previously instituted by Arthur Ali himself, which itself shows that the complaint is a concoction.
Where is the plane?
Please, you will find at page 182. Because it is prior intent.
Just a minute.
This is the proof for
Just a minute.
registered sale deed,
Hmm.
number subscription. The Dukanan number 1 wants to buy 1 bit of land from the opposite to that number.
Paragraph.
Paragraph 4 and 2.85.
Yes.
Dukanan number 1 wants to buy 1 bit of land from the opposite to that number subscription from the plaintiff and also wants to buy 10 acres of land at subscription place from the plaintiff, and both the parties ready to enter a bainanama. And accordingly, both the parties signed on the bainanama regarding the land measuring 1 bita land into sub number 190, person of 25, and land measuring 10 bita 3 person 9 person, under the same law. In this respect, on field, the plaintiff signed many blank papers and blank reviews, which were taken by the document number 1. For obtaining permission to get one piece of land, to put that number of officers from the concerned authority and refuse to the plaintiff that it is necessary to obtain permission to the sense of the land. On believing becoming the plaintiff gave the purpose to the defendant, but defendant number 1, the defendant number 2, manipulated the case and told the documents to be done registered with the city for registration of the person. And all here for a while.
According to him, the signatures are his and this was misuse.
Yes. He has said that I have signed it.
Hmm.
For one
It's
purpose
blank
that I have
documents and that has been converted into a.
only by filing an FIR say that these are full signatures. I discussed the number 14 to the 14 things, 2020 in absence of the plaintiff and sole claim was shown as Srivada to Pata in fact letters, but on 2020, the plaintiff was in general duty, which is kind of winter. The plaintiff went to provide
his signature, he was there. So subsequently, he builds up a different story. But before registration of the plaintiff came to know about the permission in respect of freehold of the land, the plaintiff immediately filed an objection to cancel the permission which was obtained in respect of freehold land. Before the plaintiff wants to say only 1 bigger of it. Agreement was for 2 bigger, now he says he wants to say 1 bigger. Because he used to make the prices 1 time. So on 18th after the receiving a notice from the central office for mutation the name to different number 1, then the plaintiff came to me that different number 1 wants to mutate his name in respect to the plan, and that immediately the plaintiff inquired about the mutation. Then the plaintiff came to know that the different number 1.
So he has made his son-in-law is also a defendant. Perform defendant.
His son, not son.
Son-in-law. Son or son. Okay, let the witness in the
Who was the baby? So this part of the plaintiff story will itself show that he stands.
two different stories are given. So it itself shows, according to you, this is the abuse. And inherently improbable, because in one place you say that you have not signed, 2 signatures are not mine. There are 2 signatures, those are also not mine. However, in this agreement, plain you say that I have signed a paper in blank paper, and that has been converted into a valuable property. This is not his case in FIR.
That is the second ground. Then thirdly, this is a dispute between, it is a dispute that is different disputes of circulation. Dispute is pending, that can be decided there. Now, these complaints are on the same set of facts. Therefore, too many complaints are only to us.
That I have written, civil, so many cases are filed on same cause of action by different individuals.
And these of the particular report you have also said, the controlling constantly you have also said. Then all the facts that have been added, this section will not get affected. More particularly, it will be the basic of what you can which are not denied by you. And lastly,
Just a minute. Yes,
and the last is that even if it is allegation of against me only.
but against the official.
Is the common officers who are over disturbing of the people. The sub-register, circle officer, among the OC of the police station, then the IO, and his son, his son-in-law. So all are bad people.
Except him. The judgment you give. Yes. Yes. But you will have to give a small either further. Either of you give me note, small one, not even one paragraph, which case filed by whom and what is the allegations, a paragraph. All these revision petitions, who filed, how the relation in the seller, actual aggrieved person is the seller. Now one is filed by one son, criminal FIR and CR, one is filed by nephew, one son is with the buyer, purchaser who made a statement, he is a defendant. So that these facts I may get will be confused. So that confusion you should make clear. Otherwise, I have already those pages you relied on, I have noted it down in flag markers. Now I'll change the pen, color of the pen. Just give me a minute. Also. I will reply দিলেন আগেটা নোট করুন এটা ফ্লিপটা মাইট আছে ওকে yes
The FIR is subject matter of felony criminal petition number 154 of 2020.
Hmm.
Then also will find, particular of the FIR, there are three fold of allegations.
yes
First, allegation that his signature were false and there was a false sending executed. And the sending was executed in his absence when he was not present at the time of the registration. Second,
Hmm.
with regard to an incident of 1/11/2020,
Hmm.
when the petitioner and along with some of his men has illegally trespassed into the land
Hmm.
and has occupied the land by throwing out them from the house and have assaulted. So the second fold of allegation is the FIR. And the third allegation,
28,000
20, which clearly attracts an offense under the PCI. Now what you will find the sending melody with regard to the allegation that his signature does not contain in these pages of the sale. So what you will find page 93 first.
yes no signature only the seller
There are too many pages. Nine, I'll just find out the page number.
Hmm.
93, 95, 104, 107, 108, 109, 110, 120, 123, 128, 129, 130, 131, 132, 133, 130.
just a minute yes
133,
Hmm.
144, 147, 140,
133
133,
Hmm.
144,
Hmm.
then 147 to 156 all in all this.
147 to
156
all these are differential leads
difference
without signature
without. So, Madam, in my humble submission, the allegation that these signatures are not there, and there is nothing on record to show that these allegations are false, to make it an abuse of process of law. Second, the other two allegations, there is also nothing on record to falsify this allegation, the trespass and the bribe of 25.
just a minute ये पेंसिल ना मेरा वो नोट होगा आपको तो yes
So, in my humble submission, in this FIR, prima facie there have been allegations made and which constitute an offense. And your worship under 482 Pahel would not judge the correctness of the allegation because that is what has been laid down by the Honorable Supreme Court. I'll rely on my judgment. So,
yes
now the CR case 458, which is a subject matter of challenge in criminal petition 157.
CR case
458.
458 corresponding to civil revision petition
Subject matter of 157.
um,
Criminal petition 157. this is again a complaint which has been filed by the seller, the informant of the FIR.
Hmm.
Same set of allegations. The purpose of filing this complaint was whether the FIR was first lodged on 13/10/2020.
Yes. Not registered by Kampur, then you went to Kaswa.
Yes, we went to this news to the FIR 1310 is usually computed.
Kampur.
But when this the FIR was lodged, but it was not registered.
Hmm.
Therefore, the complainant came up to the court, the complaint, and the complaint case has been filed on the same allegation. This complaint is filed on 8/12/2020. Subsequent to that, 13/12/2020, the FIR is registered.
So nothing survives in this case.
Yes, because even envelope in the complaint case, as per section 210, the magistrate can call for a report from the police and stay this complaint case and proceed with the investigation. There is a provision to take care of this. Now, what should we find? The criminal petition 152. CR case number 3/21.
Who filed this?
This is filed by one Mohammed Fakhruddin, who happens to be the nephew of the seller.
What is his grievance?
Yes. His allegation, you will find case 229
Of that petition?
of criminal petition
152.
152.
Okay.
May I just read it?
Yes.
Here, the accused is the petitioner. The humble submission of the above named complainant is that around 10 a.m. on 1/11/2020, the above named accused person along with 15-20 homes illegally trespassed on the land and house in my paternal uncle Mohammed Ali Azhar lived in a joint family. The accused person caused damage to the house by striking the doors, windows of the house with dowels, lathis, and ropes they had in their hand. Being not satisfied, even after doing so, they dragged my 82-year-old ailing paternal uncle Mohammed Ali Azhar and my paternal aunt out of the house. By making those goods enter inside the house, the accused took the possession of the land and house forcibly. At present, the said house and land has been under the possession of the accused. On the day of the incident, my paternal uncle went to the local police station to lodge a detailed SIR in connection with that incident. But Sri Samti Bora, second officer of the police station, kept him confined in the police station for a whole day and released him at about 5 p.m. by taking 25,000 from him. This are
Same.
The above name accused demanded that he had purchased the land from by paternal uncle Ali Azhar. Later, I communicated with the sub-registrar and obtaining the copies of the sale deeds to which the accused supposed to have purchased the land. I came to know that this registered sale deeds to which the accused had purchased the land do not bear the signature of my paternal uncle, the seller. Though 1 or 2 pages of the sale deeds contain the signature of the seller, but my paternal uncle has confirmed that those are not his signature. In addition, some of the stamp paper of which the sale deeds were registered on 13/10/2020 were purchased in the month of March, while others were purchased in the month of August.
Same affair. Same.
Now the third part. This is
152. He can be a witness, assuming we allow to proceed. This cannot survive.
the third part is his individual entry.
What is his allegation?
My photo and signature, which were used in the form for obtaining land sale purchase permission as a co-packador of the said land, are also fake and counterfeit. How could the accused obtain land sale purchase permission without taking my signature? In addition to the office of the sub-registrar, the local revenue circle officer is also involved in this fraud. The detailed proof and evidence with regard to that fraud and conspiracy committed by the accused will be furnished to the court as and when required. The witness were aware of the incident and the truth will come to light in course of examination of these witnesses. Since I was busy in collecting evidence against the accused, filing of his complaint as per period. So, his allegation is
His first part is regarding his uncle. That cannot be two things. Cannot be only you can argue that yes, his photo was also misused as witness or what? Is misused as what?
misused to get the sale permission as a co-packador.
Okay. What happened to this case?
Now, everything is still, or in all the cases. there
No,
is-
any, after the complaint was lost, any initial deposition, any cognizance order, any.
Cognizance was taken, thereafter, they have filed this criminal petition and there is.
They thought that High Court has state court will not proceed, might be. Okay, that is not an issue.
Then two other criminal petition, 156 and 153.
Criminal 153,
153
Hmm.
and 156.
who filed this?
This was filed by one person, Abu Hussein, and same allegation of the incident which occurred on 1/11/20.
That the old man lost.
The other one
Same.
assaulted and
Same as FIR.
same as FIR.
Hmm.
And the contents of the complaint filed by authority
152.
150. So this allegation.
So it's a clubbing of allegation of the old man and his nephew by the other son of the old man.
These two,
Okay.
156 and 153 doesn't say about the allegation which has been leveled by Paparuddin in 153.
Okay.
That is not. It is only with regard to the incident that has occurred on 1/11/20.
Only relating to 111.
1/11.
That is already pending in 152.
In 152 and the FIR.
Third part.
Right.
Third part in 153 that my signature is used.
Yes.
Now, what are their business that this is being used? The seller has lost the FIR. The person who says that my signature is, my photo is misused, he has filed a complaint. What is the business of these two things?
These are kind of the allegations of assault and the only these allegations are.
Assault not upon them, assault upon somebody else.
The father and the family.
But that has already been lost by the victim themselves. Who are they?
These two, the other day that I pointed out. Was
Okay.
So one of the essentially the ground in all these criminal investigations are almost same number.
Hmm.
First is pending title suit
Hmm.
and allegations, disclosures, transactions, civil in nature, and prejudicial to the trial of the civil. Now, in this minute, I will rely on a version of the other. First, 2009 5 SCC 528.
Hmm.
Whether from piece paragraph 21.
Paragraph
21.
21.
And
Okay. 24, no?
paragraph 21 to 24.
21 to 20. These are the judgments allowed.
And paragraph 43 and 42. 24, the Supreme Court relied on a constitutional bench judgment.
KG Parameswar. And then last paragraph 46 and
41,
43 and 44.
43 and 44.
Hmm. Okay, so you are saying that even in relation to that trespass, 506 and something like. Okay, then
Another judgment of 1999, DSCP 259,
1993,
1999.
why you require so many judgments?
DSCP 259.
1998, I got 8 SCC. Then 2005, 13 SCC. To 2021, 5 SCC. Then 1992, 1 SCC. And 1993, 3 SCC. And 2021 Manu. Hmm?
Last second. In between, the last one.
2005. Okay, okay. 1998.
1999. Yes.
I have 1999, 8 SCC, 7 to 8.
Let us quickly review it.
Yes, which citation?
1999,
Hmm.
3 SCC.
Okay, you have given 8 anyway. It's usually slowly.
259.
19.
Rajesh Badal versus
Just I'll record it. 1999, 3 SCC. Space
259.
259. Okay. Read it.
Rajesh Badal versus state of NCP of Delhi and others.
Hmm.
There are 9 reads from Para.
Yes.
It is not necessary that a complaint should verbatim reproduce in the body of the complaint all ingredients of the offense is alleged. Nor it is necessary that the complainant should speak in so many words that the intention of the accused was dishonest or followed. Speaking out of the definition into the different components of the offense to make a meticulous scrutiny, whether all ingredients have been precisely spelled out in the complaint is not meet at this stage. If factual foundation for the offense has been laid in the complaint, the court should not hasten to press criminal proceeding during investigation stage merely on the premise that 1 or 2 ingredients have not been stated with the court. For pressing an FIR as state which is permitted only in extremely rare case, the information in the complaint must be so vivid of even the basic facts which are absolutely necessary for making out the offense. In state of Haryana versus Badalla, the court laid down the premise on which the FIR can be pressed in rare cases. The following observation made in the appropriate decision are a sound reminder. To also give note of a caution to the effect that the power of pressing a criminal proceeding should be exercised very sparingly and with circumspection, that too in the rarest of rare cases, the court will not be justified in embarking upon an inquiry as to the reliability or genuineness or otherwise.
That has everything been relied on by Mr. Chaudhury's judgment. All principle is paragraph 27.
So basically, the and one judgment 1992 supplementary 1. Here, the Honorable Apex Court says while exercising the power of, it was a case of 226 where the FIR was put to China. The Honorable Supreme Court says that the document which is annexed with the quashing petition should not be taken as an evidence to negate the allegations that have been made.
Paragraph.
There are 23. There are 20 and 20. there was also a case where the allegations were that there is a malafide intention on the part of the complainant in lodging the FIR.
We are 23 and
20 and 20.
yes.
Three paragraphs from the 2021 Highway CC 795.
2021 5 SCC
795.
paragraph.
Paragraph 40, 41 and 40.
Okay.
Lastly, the working with the right hand construction.
As always used. And what about 2005? 13 SCC,
2005.
13 SCC 540. Have you relied on this?
Yes.
Okay.
Paragraph
Which paragraph?
8, 9, 10, 11 and 14.
Okay. Now tell us one thing. Should we endeavor or write judgment so far relating to CRP 153?
153 and 156. To be fair, this allegation has already been taken care of.
So you make a submission that we are not pressing this. Not pressing the criminal proceeding.
No, not received.
So CRP 153,
156.
156, that is both those CR cases you already dismissed for default, and you are saying that you will not pursue those
No.
cases as the FIR and
And the
complaint gets by the nephew, third part
Takes care of
it takes care of it. This is your case. So that we did not go. Now we'll have to see on the basis of argument of Mr. Chaudhary
152,
whether this is a case.
and in 157 also.
Ah.
Here, the only difference in 154 FIR and complaint is that here two more accused have been included. One, the informant's son and his son-in-law.
In which CRP?
In criminal petition 157. CRP 4458.
458, 157. By seller,
By say,
nothing
Who?
survives.
who files the FIR.
Nothing survives.
Only difference here in the complaint is he has implicated the son and his son-in-law. But the allegations are same.
Same.
And I have pointed out that this complaint was lost because the FIR was not registered by them.
Okay.
And the page 82 and 83, the statement. The statement of the witnesses which has been recorded, that is the informant, son and the son-in-law.
Who are accused.
Who are
Accused.
so they are
You allege that these are the conspired with the petition.
defeated. So, in my humble submission, their statement will have no credibility.
Hard. Anything to answer? Motion. Give that note, keep it. This is for us, huh? Give that note. We'll dictate the order in court, not today. I give the note and a short note on your argument so that I can dictate quickly. Huh. Fine. Those dates are important.
And that was prior in point of time, and in the FIR, we does not see also, so already been executed.
So you just give those points. I have noted it down. What are your arguments? But one liner you can give also.
And this is this is the logic.
Hmm.
To satisfy the logic that we do this kind of regarding the payment of money. Regarding the regarding party escape into the those are not basically.
Yes, yeah.
I think those are not part of the system at all.
Okay.
This one is 2012, one is to see.
Just a minute. 2012. Mostly this is also for us. 2012. One SCC. Oh, change the pencil. 2012. One SCC. 520 paragraph.
Paragraph will be 19 and 20.
Anita Malhotra.
And same point, there is another discussion. According to this, 2014. 2013 within 3 of the two. Is 220.
Paragraph
Paragraph 29 to 30.
29 to 31. Listen. Okay, that principle is laid down 30.123. Okay. Heard at some length. List this method for further hearing on 22nd of September. Shorter date, huh? In fact, I'll start the dictation from today itself. I'll give a shorter date. We'll just dictate only, or we may get some dictation done inside and 18th. Yes. Before. If give it on Monday, it may so happen that we'll just dictate it and deliver on that day. That is idea. So if you can give by Monday, too short. Tomorrow is too short. Okay, now yes, sir.
I think 64.
Why? I compromise. Joint petition. Can 3476 be compromised in terms of Lakshminara? What it says? 376. Huh? Are you having that judgment? Okay. On the prayer of the learned counsel for the petitioner. There is a recent judgment by my Lord Justice Gawai.
I can go ahead and say record. The judgment is the record.
Okay, on the prayer of the learning council for the petitioner, matters stands adjourned and be listed. When? Be listed after 3 weeks. On a date to be fixed by registry. Interim order pass হয়ে গেছে।
65.
Buঝলেন?
We do not, petition has been filed because the proceedings has been taken against the petition under on a petition filed under section 319 matter, without there being prosecution matter. That is the main ground.
Where is the order?
The interim order is at page 32 matter. Petitioner while charging.
Just a minute. Page
Page 32.
what was the allegation? Sure.
Allegation by the complaint is that annexure 1 page 14 matter.
Is
Page 14 matter. Allegation is that the petitioner is registered as paragraph 4 and 6 matter. Complaint is that page 14, the revision portion is 2 matter. Petitioner is Kanungu Abdullah. Page 15, paragraph.
this is a search sheet or complaint? Complaint, share case.
Yes, yes. That case was sent to the OT Dolgaon, and according to case has been registered and RC has been filed matter.
Paragraph 4 and 6.
4 and 6 matter, the name of the petitioner is here. From the basis of this complaint matter, Dolgaon, yes, case number 62515 has been registered and subsequently RC has been filed my lord. And the RC, you will find that case my lord 22 matter. That's it. Page 22.
What is this written argument file? We're supposed to file an affidavit, isn't it?
Yes. Objection,
What is your written argument? Is this a Jamabandi of surveyed villages document of the part of the record?
No, no, just we are viewing,
Are we at trial court?
no,
If we are not trial court, can we say that these Jamabandis are manufactured and issued by the accused?
no, no, just we are for final cases.
No, his whole question is that your allegation is that during his performance or performing his official duty, he submitted a false report.
Yes, yes.
False report
Yes.
to his higher authority,
Yes.
and higher authority on the basis of this granted mutation, something like this. So you were deceived. Now his question is, then thereafter the accused also deposed against him in the during the trial examination.
Yes.
So court has exercised its power under 319. A basic issue is whether from the allegation in the complaint as well as during the deposition, a case against him is made out to exercise power under 319.
Yes.
This is the basic issue. So therefore, we look at the complaint and the evidence, not beyond that. This is first part. Second part, what he is arguing is that even if I made an accused, sanction was required. What you argue on that?
Yes. Well, sanction is necessary when he discharges his duty as a matter of official duty. But our in this case, that his duty is not official duty, is by erasing his official capacity. Or his document.
So according to you, when a person abuses his work and does forgery, there no sanction is required. That is your case?
Sanction is necessary, but it can be taken any mistake. And then let's try to avoid. Any mistake it can be taken, sanction and penalty.
Any authority on that?
Yes, rely on government. And in our written argument.
This is your case,
Yes.
particularly no sanction.
Not sanction.
This is your case, no sanction.
My contention is that the petitioner was performing his
So official duty, he prepared the report as an
No. He did not prepare the report. My not, the report is
prepared
prepared
by
by
the
the Mondal.
Mondal. You have signed this.
He as a canon good, for better canon good, his duty is to place the record after the concerned Mondal submits the report. He will place the file before the concerned cycle officer. That is his official duty, my lord. So that much he has performed, and even in the service also, my lord, that has been mentioned. Because he has not done for the field verification, and it is not his duty as a supervisor canon good matter. It is the duty of the last Mondal who has made the field verification. It is not the duty of the canon good to make field verification. Whatever Mondal form in the field, he will submit a field verification report, and he will only prepare the file and put it before the cycle officer. That much duty as a government official he has performed. Thereafter, my lord, that is first ground, and second ground is, my lord, since he has performed his official duty, my lord, in terms of the various judgments made by the Honorable Court as well as the Apex Court, my lord, the sanction under 197 is required, my lord. So without sanction under 197, even under section 319 also, my lord, he cannot be treated as a accused, my lord. And I have relied on a judgment of the Supreme Court where
2016.
Yes,
2016 8 SC 722.
yes, my lord. On this, exactly on this point, whether under 319, my lord, if the person may be treated as accused or not. Even my lord, in section, in an application under 319 also, my lord, sanction is required, my lord. Paragraph 30 and 31, my lord.
Paragraph
30 and 31, my lord.
paragraph
paragraph 30 and 31, 30 and 3, plus, two paragraphs.
But this relates to a PCA.
No, I don't agree. I don't agree. It says about the 197 also. Paragraph 31, my lord, because the logic is clear, my lord, because against the sanction or in favor of the sanction, there is a relative. Either party can exhaust, my lord. Paragraph 31, according to the learned counsel representing the position concluded about to keep the determination entered by a court under section 319 of the code is subservient to the decision of the competent authority under section 197. No, not at all. The grant of sanction under section 197 can be appealed by the accused by taking recourse to judicial review. Likewise, the order declining sanction can similarly be appealed by the companion order proceedings. That is the logic, my lord. Because it's a sanction that can be appealed by either of the party, my lord. There are 31 clearly speaks about section 197. My lord. Paragraph 30 says sanction is required either in the PCA under the PCA or under 197. My lord, the previous sanction is necessary. My lord. Whether it be under PCA or 197 PCA, the sanction is required. My lord.
This is basically section 19. Yes, what you say?
Yes, that is for the renewal judgment. Now we are relying upon to achieve the judgment. Here is stated the normally text for that. Look, paragraph 17 will give our written as well.
Keep the judgment.
Paragraph 40.
What is your evidence? Give his deposition.
Deposition is not easy, but LCR of small for like last.
And share is there. Also.
So let it is a teamwork.
You come to start. You are Mr. Rakul Das. And who is the informant? Sultan Ahmed.
Sultan.
The other accused are father, brother, and
case for quashing whole the process. Forget about him. What is the material against them? Forget about 197, tell us. Your chief and your cross-examination.
Otherwise, it's only teamwork. Without my lord,
Your word will have no value. Word of your client is having value. He admitted land belonged to his father. He admitted that there was some Sita mutation in his name. He admitted that his father filed cancellation of mutation in your name. You file application for restoration of your name. And one line that so and so has posed document. What document posed? How it was posed? Nothing is therein. And that too in a cross examination. In chief, nothing. He has not taken name of anybody. Forget about 197. Whole proceedings. What are your grounds? Only 197.
97 and the enforcement also. The enforcement also. Because my lord, healthcare I have not done so.
Go through this and come back some other day. You should get a chance. Instead of writing a written argument, you better go through this. Yes, public prosecutor, go through it. And he is the main informant. See his evidence. What criminal case is made out, tell us. And enlighten us what are the criminal cases. Except stating in the cross examination, he has posed the document. What document posed? He himself says that land belongs to my mother and father. There was a Sita mutation. What document? How? All these are my brothers. Suggestion was that land belongs to all. He admitted that my father neither sold or gifted the land to me.
And importantly, now my lord, that order has been before the concern investigation, my lord. And
Oh no, he filed revenue appeal against that. Everything, this is absolutely nothing in this. No criminal, even flavor is there. Go through it. Go through it. I'm keeping all your judgments here. I will hear some other day. Go through it, both. Madam, you also go through it and flag mark.
your lordship has, on the last occasion, today also, my lord, your lordship has had in thanks, my lord.
You will say no part out. You will say no part out.
So it may be careful.
Hard at some length. However, the learned additional public prosecutor pays for some time to go through the scan copies of the LCR and to the deposition of PW1, on the basis of which the impugn order was passed. Was passed.
Lovely.
20.
any other 20.
25.
20.
Okay.
Go through it.
I think 70.
Mhm.
70. Supplementary losses.
Yes, what is this?
70.
My lord,
Supplementary.
I can 65, interim order passed.
Interim order passed earlier. 67. Hearing or what? Passing is up to 65.
70.
Where is the supplementary?
Supplementary secretary.
Where is
That
the-
case, my lord, I was trained by lord, I have to take this. Today, was supposed to track on my lord, I carry upon merit of so. Now that case, my lord, the last question was
Okay, now I recall. What is the issue here?
my lord, in this case, the law, the process of panchayat election,
Hmm.
the petitioner has submitted his provision of a certificate,
Hmm.
which the informant stated that this is the false documents I have submitted.
Hmm.
I have exhibited all my original documents to law, and for the last, including a mark sheet, provision
Who will verify all these to be correct and genuine? This court. This court.
This is called certificate number.
Huh? No, tell us. We'll peruse everything. Tell us and enlighten us our power to verify a record to be a genuine.
Can we see? Having the certificate, original certificate shows the seals from the examiner. And their confession is just stating that there is particular examiner is not passed below. You know, prove it. Because I know whether I had passed the examination or not. And this was true.
Why are you
This is.
Why are you thinking that police will further file a search sheet? Where is the FIR? Already search sheet filed. Scan copies are. If you want to argue,
Charge was filed, my lord, charge was framed, lawsuit, it was a written state, the evidence was called for lawsuit, witness appeared, my lord, but because of my lord, interim order lawsuit.
any scan copies of the in discussed question?
The authority, my lord, they reported that the certificate is a fact, no record is there lawsuit. Your honor, if you lawsuit permit my lord, one judgment, I will submit my lord.
Germany is not necessary.
Three flags are there lawsuit. On the what I have to decide.
What is your roll number?
Number is 9, roll is 9, number is 4208.
4208.
My lord,
You have passed from where?
my lord. This is, Lokhikanto Sinha, Sukulpati, Sundar. I have arranged the mark sheet also, that is at page 30. Then the original certificate at page 31. Page number 29 is the provisional certificate issued from the.
Bring the Pradhan Adhyapak to the witness box and prove it.
Another, okay, just before I have to do that is from the office of the vice principal, who has certified that, I need to do that.
Where is the original of this?
This is not with me, this is, I think, the vice principal. Where it is clearly said that this is a information regarding certificate issue, madam. From the office of the vice principal. In respect of your letter number 72, it is informed that the candidate with roll number so name not expired has passed the procedural exam 2014 conducted by the Assam Sanskrit Court. The Academy of the Assam Sanskrit Court was handed over charges to the university on 23rd March 2018. Therefore, the university is not in a position to verify the document and required execution prior to 23/1/18. It genuinely shows that he has passed the exam. And he has produced all these documents.
Where is the search sheet?
The sheet is at page number 17. Relevant document find at page 18.
The case diary, how they proceeded.
But in fact, the original affair is not. The bigger picture original affair.
Who is Rezaul Kabir? Who is Rezaul Kabir? Son of late Bapijan Ali. Okay, that is a SI. SI Bipin Sheikh here. No. We want a case diary. But your register has said this document was seized. It says, as per record received from Assam Sanskrit Board, Kahlipara, Guwahati 19, the candidate with roll number 09, roll 09 number 4208 has not passed the Praveshika examination 2014 held by Assam Sanskrit Board.
This is the.
As per the evaluation of Praveshika, there is no record found of Muzaffar Rahman roll number so and so so and so. That is the difficulty. Now, sir, tell me, should I believe this report or you? And if this is a report not seized by during investigation, what was your statement during investigation? Have you produced this?
Yes,
Your documents are seized.
I have submitted my original document and all this and all.
So therefore, whether those were sent to the forensic or not, whether it was established, that is all these are matter of trial. Tell us, I am with you. Assume that I am with you, I want to allow your petition. The case diary reflects that these are the forced documents.
But one thing may be done, the knowledge the competitive related verification of this certificate, whether this.
Can we, are we here to see?
Otherwise, this process, the tendency of this case will be the basis for it to go along. This petitioner has produced all these documents, they are made only section.
That's why we'll have to see the case diary, whether those documents were sent to the forward. Scan copies are come, but not case diary. There is no 161 statement.
Evidence is not.
Are you having the copy of the evidence?
My lord, no lawsuit. Now evidence statement on record, my lord, instances will fall for law. Only when one thing was by on to submit one judgment file. What can be considered under section 482 lawsuit? My lord, for lawsuit charges, the right of that is very clear lawsuit. You lawsuit is something.
Let us
You lawsuit, my lord.
let us understand what 482 is.
Yes, what is it? Only record of the charge sheet.
What is 482?
My lord, the paragraph 10 and 11 pending lawsuit.
Yes. What it says?
No judgment,
Yes.
my lord. Before considering the regular submissions of the parties, the decisions of these court on the principles which the High Court must keep in mind while exercising the jurisdiction under section 482 CRPC at the stage of training of charges, while considering the discharge application are required to be referred to and considered. In before, this is the 2021 8 law. In before number 2, to which one of our Dr. B.Y. Sanderson, Justice, is the author after considering the other binding decision of this court on the point, namely, Amit Kumar, so, it is observed and held that at the stage of training of charges, the court has to consider the material only with a view to find out if there is a ground for believing that the accused has committed the offense. It is observed and held that. And
We
that-
want to see your mark sheets are seized, your original mark sheet and things are seized
I have produced the, I have produced the IO.
and taken back.
I don't have.
You will know nothing. And these are the vital questions. Because there is a seizure of original school Pravasika examination passed and verified report. So we'll have to see whether this was authenticated through forensic. We'll have to see the case diary. Even if we go by your judgment,
If evidence is there, lawsuit, the honorable court lawsuit, and only,
what are the materials?
my lord, mental is record, test record, what, this is before you lawsuit,
No, before me, there is no 161 statement.
my lord. That is a statement, sir, my lord, of the, my lord, controller lawsuit of the constitution of some lawsuit.
Will that be a gospel truth until and unless his claim of that these are the original certificates, I have passed it.
My lord, that cannot be considered a this stage lawsuit. It cannot be, my lord, legalized, my lord, whether it is legal or not. That will be, if, my lord, he faces, my lord, my lord, petition as trial lawsuit, if he, it is, then, my lord, he will be acquitted.
So why should he face a trial if you have not sent for the original certificate for forensic and a report is there that these are the not fake?
My lord,
Then why should he face the trial?
my lord, author of the certificate, if he refuses that, these are the-
Oh, author of the certificate may come and say, what is that author says? It says that there was a shift, we don't have the record. Is there anything on this exhibit that this is a fake force certificate?
not a, it is not in the office lawsuit. If it is not, record is not here, lawsuit, passing certificate.
The record may be missing, who knows?
is here.
So the certificate, according to him, these are the two certificate original. Those are seized.
And those were considered lawsuits. These are investigated lawsuits. Materials available on report. IU has collected the evidence lawsuit. The charge sheet was submitted and.
So-
lawsuit.
We cannot waste time like this. Though the learned, in view of the order, pursuant to order dated 1/9/2023, the learned counsel for the petitioner submits that he will like to, his client would like to pursue the present application. Full stop. In the present application, case diary, scan copies, though scan copies and record of what is the name of the case? Record of the PRC case number 1288/2019 was called for. However, the case diary and 161 statement or any other material on the basis of which the search sheet was filed is not available on record. Accordingly, registry to obtain the case diary of Taki PS case number 17/2019, which is part of PRC case number 1288/2019, pending before the judicial magistrate first class Hojai. Judicial magistrate first class Hojai. Place this matter on an interim order. List Give a date, Counsel. Huh? No, not November. 17th of October. 7th of interim order pass earlier. We bring the original of this.
For admission at number 16.
Yes,
My tax proceeding was there. And
we'll hear this matter tomorrow and dispose of. List this matter in hearing column tomorrow. Admitted, that's right. List this matter for hearing tomorrow.
17.
And we'll allow your petition tomorrow. Any other side is present? Okay, we'll allow your petition. That's why we fix it for hearing because it's already admitted. Yes, what is this?
my question is a transfer petition.
Yes,
I am the white man.
uh,
I am from Mumbai,
yes,
around issue.
uh.
And the case is pending in the Supreme Court. That is because
What is the case is filed against you?
against
What is the offense?
offense by that, I am the wife of the opposition.
Hmm.
My husband filed this.
What is the that we
The case is that this is 279, and I am the wife man. While the driving out from me from his house, I have taken some pictures.
yes.
Hello. In this case, Lord, they have preferred this transfer petition only on the ground of inconvenience. Hello, in this, they have also filed a case law, which is numbered as PRC case number law in December. And wherein they will have to appear. I think the only ground, convenience, cannot be considered only on.
What case have you filed? History 79.
No,
FIR.
another section is there. Not only 379.
What is yours here case? 498A.
Only. My lord.
Why have you not filed an application to transfer 498 to
I'm going to file that.
you file it? You file it, then we'll hear this both. Yes. You take recourse to the judgment of Rupali. I am helpless. I am taking shelter at where?
My parents.
Where is your
my
parent?
mother-
Small load. So therefore, though I file, now I cannot continue. On the prayer of the learned counsel for the parties, please this matter. After 2 weeks. Why are you fighting? Why don't you go to mediation?
That can be there.
Huh?
He is doing something. Madam, where is the madam? He said, "You can't get-"
No.
He is not doing.
Okay.
But the actual question is
Okay,
otherwise.
okay, no stop. We understand. List
18.
Minor that interim order.
interim order pass earlier.
Okay.
Agreement?
18.
You sure?
Admission.
Affidavit file?
Huh? Both the party today.
Okay, the affidavit file in terms of order dated 7/8/2023. It is submitted that both the contesting parties have filed their respective affidavits in terms of order dated 7/8/2023. Same is not on record. Registry to verify and take the same along with this record and this matter after vacation.
There's a fixed date will be there.
Any urgency for you?
I think so, no, that is at the scale. Maintenance order is
They are already getting maintenance.
All maintenance is there.
not whole work.
Okay.
Technical maintenance, we are getting what we expect.
7, it will go to 7/11. Try to give before this maintenance husband, wife, this should not go. September. 19th of September.
19.
Yes.
So that this is a criminal fee.
What was the period of sentence?
1 year.
Admit, admit, call for the record,
Lordship,
issue notice, returnable on so and so, so. Where is the IA?
5 year.
Unlawfully 19 September, October, December,
October and September.
19, 26.
Okay. This is considering the period of sentence and the material available on record. It is provided that the petitioner shall remain on petitioner, the appellant petitioner be allowed to remain on previous bail. First of I stands disposal.
Up to the time and what's before the market.
So we said that you will remain on previous bail.
Continue.
Continue.
No problem.
Previous.
That's the immediate concern.
Yes,
Just-
yes, yes. I stands disposal. Shall private party, yes. Is there any private party? Informal, only state, sorry. Mr. Goswami accepts notice on behalf of.
Not right.
For hearing 1966.
Yes, yes, yes. What is this?
And sentences, period under that is
2 months, 4 days, sentence under 354. He has already undergone. All, are you pursuing this on merit? Okay, okay, okay. Give the, yeah, give the. No, record. The conviction was for for 2 months. There was no stay. He was arrested. Oh, acha. PW2 is the victim. Minor 6 years.
That is the case of 2011, that is 2012, and it could be 7 years.
Which PW3?
Neighbor.
What to do? What intention is required? The fact is committed. Her evidence remain unshaken. No, as per her deposition, her having a copy unshaken, 6 years old girl, 5 years or 6 years. Of proof. Okay, let us see them. Let us see them. But you have not 161 and 164 not confronted to her. If you see cross-examination of the PW2, there is no confrontation. Nothing that you have not said. And the magistrate asked certain questions to her. She thoroughly answered, so she was a capable witness. No doubt